base. What is the matter? But this is regarding bank guarantee. No, what is the application number? AP number 695. Application under which provision of section 9. Arbitration. Yes. But can it be tomorrow, because I think may or may not be. No, so tomorrow I take up different matters. No, but Saturday, because otherwise, bank guarantee, an expired bank. Saturday there is no court. Yes. Saturday, kindly appreciate Saturday. The bank expired bank. I take up different matters, sir. You should have mentioned previously. It was supposed to be listed on Tuesday. This may appear tomorrow if the file comes, but I cannot assure you that it will be taken. Hand over. Only urgent. Section 11 can wait, but section 9 there is urgent. It will appear as soon as the file comes. Yes. 34 don't mention now. Appearing as item 1, wait till I come back. Wait till I come back. I will wait. No mentioning. No. Updated it because there was urgency. Despite no, it's also not right now. Yes. Mentioning what? It will appear to be mentioned if you want to withdraw. To be mentioned for withdrawal. Yes. Whenever the files. Then it will appear on in the monthly list of August. It has to be mentioned. Yes. What is the matter? What is the matter? Not in the form of 37 application. But no, wait for something. Wait for something. Yes. 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 Section 11 application appears complete manner. But some urgency. Once your option is back, some precedence. Please mention there. My lord, item numbers 291 and 290. My lord, I'm saying for fixing up a date. Learned senior counsel application. I will be traveling from Bombay. We will wanting. I'll not be there for 2 weeks. For 29th August, we wanted a date fixed. My lord will kindly. This is an application under section 34 and a connection section 36. Both very well 29th August at 12 noon. 12 noon. But I'll fix timelines. Yes, my lord. My lord, I have given notice. I will tentatively 45 minutes each per my lord. Keep that in your mind and remind me when I take up the matter. Yes, yes, I will know. Under which provision? No, what do you want now? You want a correction in my order? Hand over to be mentioned for correction. Yes. Section? Section 30, yes. Call this. Listed matter, item number 1 to be mentioned. Item number 1 and 2, but I'm assigning the notes on arguments on calendar response. It was only for that purpose. Yes. Yeah, you are for the respondents. You have already filed. You are also. Learned counsel for the parties file the written notes of arguments, and hearing is concluded and judgment is reserved. Thank you. Get a party. Item number 3. देखिए order section. The main matter had been dismissed or deferred on May 21, 2024, full stop. Even today, when the registration application is taken up for hearing, none appears to move the matter. Full stop as a last chance to the petitioner to move this application, the same is adjourned for the day. Full stop, it is made clear that in the event the petitioner remains unrepresented on the next date when it is called on for hearing, the matter shall be dealt with expertly. এই অর্ডারটা পড়ে দিন দেখি অর্ডার শেষ সবসময় দিয়ে দেবো নেক্সট for settlement item number 4
submitted that they have made the payment. I have disputed that. My Lord, director will to file affidavit disclosing how the payment has been made. But they have not received it.
Some queries are put to the client which have not been resolved and paying for time is not being
But they have to produce the bank statement.
I have statement, my Lord, if you got wishes without affidavit, I can hand up a document.
It will appear under the same meeting on
On
5th August. Same meeting. Since certain instructions are further required to be taken by the award debtor, let the matter stand
No, I want letter one. Section application, section 9 application.
by the respondent in the section 9 application, comma, award debtor by the respondent in section 9 application, comma, let the matter be listed under the same meeting in the monthly list of August.
Item number 5. Item 5 and 6 have settled the matter. Page 12 is the negotiations that we had. Paragraph 1. 3 matters are being settled. It was agreed that this sum will be paid the full and final settlement in all 3 matters within 3 days of appropriate order. So I'm praying today only for prayer B of my petition. This petition has been jointly approved by both of us, so that they can make the payment, and when your lordship comes back, they can withdraw their.
Yes.
The outer limit is 2 weeks, so 3 days to
Yeah, my lord will come back anyway after 2 weeks, so I'll keep it at about that. My lord, only one more thing. There are 3 matters by the same settlement. 4, 5.
Others may appear.
No, and it's appearing as 4. That was an execution application.
The regular page.
No. Your lordship,
my
this item 4.
So this will appear along with those on the next day.
happening today. Other matter is happening to the regular place at 2 o'clock. So ultimately, pass orders.
Then I'll pass orders.
No, one order in one application is enough. It's all 3 identical.
Very well. Since the parties have agreed to terms of settlement, comma, the petitioner is directed to make payments.
Petitioner, I am the respondent.
And the state of West Bengal is directed to make payment in terms of prayer B of the present application within 3 days, within a fortnight from date. The matter shall be listed on August 6, 2024 under the same heading. Along with, please give the other numbers. And when that matter is taken up, keep somebody to mention.
Yes, I even separate orders.
Why separate order?
Separate orders in each of.
Why? No. 4 and 5.
5 and 6.
5 and 6. 5 and 6.
And 4 in the
4 also.
4 in the regular.
4 in the regular.
না 5 and 6 করো আর along with যেটা বললাম রেগুলার লিস্টে যে আইটেম 4 আছে সেটা ঢুকে তার নাম্বারটা সেই নাম্বারটা আজকে কল করবে ঠিক আছে ক্লিয়ার তো
For examination of judgment letters, item number 7.
Yes. I am appearing for the award with adoption. This matter was taken up on 15th of July 2024 when 2 objections were taken on behalf of the judgment letter. One being the earlier execution application was dismissed for default, which was never restored, and then we had filed this execution application. And second, they have said objection under the territorial jurisdiction in view of the forum selection clause. So, Lordship, let me satisfy your Lordship on these 2 points. Lordship, I am relying on a judgment of 2022 Supreme Court cases 407. Lordship comes in paragraph 11, which gives the findings of the impugned order, which are quite similar to this. The High Court finds that the earlier execution petition filed in the first executing court, namely execution application so and so, having been dismissed, the application which is filed subsequently in the year 2006 before the second execution court, if we may describe it as such was not maintainable. And it is found that the first application having been dismissed for default, the proper courts have been to approach the state court within the period of limitation. So this was the impugned order. Lordship, comes to the contentions of the parties, which is at paragraph 14. So and so learned senior counsel for the applicant with reference to the facts as we have noticed make the following submission. He would point out that the mere fact that the earlier execution petition was dismissed would not stand in the way of the processing and considering of the second execution petition. The execution petition was dismissed only if at all on account of default. In fact, it has been withdrawn with liberty, but even if it is dismissed on default in view of the law laid down by the judgment of this court in Shiv Shankar Prasad Saab versus Vaikuntha Nath Singh, the second petition was maintained. Lordship, then comes to paragraph 15. Platinum C. Therefore, the second execution petition filed in the year 2006 was well within the period of 12 years, and therefore the execution petition is not barred. So, Lordship comes to the finding of this honorable court, which is at paragraph 25, page 18 of this judgment. The first question we have to consider is whether the dismissal of the execution petition filed by the applicant arbitrarily on the ground of default or withdrawal of the first execution petition will result in a bar for the filing of the prosecuting of the second execution petition. In this regard, in fact, we must notice that the learned counsel for the respondent does not seek to raise any objection as such to the contention of the applicant that the second execution application would be acceptable provided it is within the period of litigation. We also find merit to the contention of the applicant that mere dismissal of the first application on the ground of default may not result in the
Very well. Here the limitation question is not there.
Now, Lordship, coming to the territorial jurisdiction. Lordship, I will rely on the judgment of
69. 1969, you have given another copy. You'll also rely on this? No.
Lordship, this is being referred in this judgment.
That's right.
Lordship, for
What
the
about the other one? Yes.
territorial jurisdiction, I will call upon on 2018 three Supreme Court cases 622, that is Sundaram Finance versus Abdul Samad. Lordship, here I will be relying on
What is their objection on the ground of territoriality?
on the forum selection clause. Lordship, the clause is at page 26, which says, subject to the provision of clause 23 above, suit, petition, reference, or other filing permitted, so and so shall be instituted in the competent courts at Mumbai. Well, Lordship, my argument is in the case of execution application, this competent courts of Mumbai will not be applicable because of this judgment of Sundaram Finance, which says that
The arbitration seat was Mumbai.
arbitrations. Lordship, it was
Mumbai, very good, yes.
Lordship, in the Sundaram Finance judgment, Lordship, it comes to Placidum A, which is at page 3. And award under section 36 of the 1996 Act is equated to a decree of the court for the purpose of execution and only for that purpose. Thus, while an award passed by the arbitral tribunal is deemed to be a decree under section 36 of the 1996 Act, there is no deeming fiction anywhere to hold that the court within whose jurisdiction the arbitral award is passed should be taken to be the court which passed the decree. The 1996 Act actually transcends all territorial barrier.
So something has happened within this jurisdiction. Part of the cause of action or
Lordship, the agreement has been signed between
what is the subject matter of that?
Lordship, in a long-term hypothecation agreement, it
Part of the cause of action is here.
arose here, Lordship. In this Sundaram Finance judgment, it has been said that any courts, one which has passed the decree or where we apprehend that the movable or immovable assets of the judgmental debtor could be there. So this, if I take it to Bombay, then I have to do a transfer decree and again come back over there.
Where is your application? Where is your application? Your application.
Lordship,
Show me the invocation of jurisdiction in your application.
Paragraph 43.
Paragraph 40.
Paragraph 40. The loan car hypothecation agreement dated 14th March was executed and concluded at the registered office of Tata, which is at Park Street, Kolkata 60. And Lordship, they are in North 24 Parganas. They cannot have any assets in Bombay. And Sundaram Finance says that if I know that this person is living in the jurisdiction or nearby jurisdiction, and Lordship, now their affidavit of assets has also come, which does not show that there is any immovable property which is outside this jurisdiction. There is only movable properties. There are bank accounts which can be attached from this court.
Yes, yes.
Not kindly come to the tabular statement. Kindly consider the 6 in 3. 6.
Yes.
Column number 6. Withdrawn on 11th November 2009. Disclosure made by the applicant in the tabular statement. On support of this, kindly come to paragraph. Paragraph 28. Assignee of the award holder being Kotak Mahindra Bank had withdrawn the said execution application number such and such with the liberty to file a fresh copy of the said award. Now,
It is not correct because the order does not say so.
order is on
Yes,
second
Mr.
court, for default.
Yes.
Now, not only that, kindly come to the affidavit portion. Paragraph page 70. What does the deponent say? The Lordship has seen paragraph 28 is as regards to the knowledge of withdrawal. Now see what they are saying, the applicant.
Information received from arbitrator.
Receive from the arbitrator. So no X or tail. The order says otherwise. Contentions of affidavit says otherwise. Information received as per the contention of the deponent received from the arbitrator. So all are misleading. I don't want to use the term, but it is apparent from the record. Now, my humble submission is, if this factor was disclosed at the very first instance before the court, when this execution application was pressed, I don't think any order would have been passed. This was completely suppressed by the agreement.
What about the territoriality, the next one?
Yes, Mr.
If I may add the
No, not now. Yes.
Now, we not kindly take the award where the arbitration was held.
Mumbai, they admit.
It was in Mumbai.
Yes.
May I refer the governing clause, additional clause, forum selection clause.
24 point something.
Yes, it is appearing at page 26.
Yes.
Clause 26.
Clause-
Yes, Mumbai.
Clause 26.
Yes, clause 26. Jurisdiction.
24.1. Ask your Leonard Junior to give you your glasses. Yes. But you can take my glasses also.
I'm getting.
Yes, let us not dwell on that any further. Yes, 24.1.
It says that exclusive jurisdiction shall be court of.
I have read it. I have read it. Yes.
Yes,
Mumbai.
sir. Now,
What about the judgment of the Supreme Court, which has been cited?
now the
Ishwai Low, what is your answer?
yes, as though I have not gone through the whole judgment, but apparently the issue as regards to order, your lordship is aware of the award passed under arbitration becomes a degree under section 36 and the degree is possible under order 21 and the rules made there.
Doesn't become a deemed degree under the 96 Act, but yes, you are right. It has to be enforced as per order 20.
As per order. Now, we will kindly consider 100 of order 21. What does it say? And this these discussions did not take place in the judgment because the respondent therein did not take point on the issue of maintainability of the second execution application after dismissal. So it was really not discussed. We will kindly take 105 first of order 21. Hearing of application. The court before which an application under any of the following rules of this order is pending, may fix a date for hearing of the appeal. Where on the day fixed or on any other day to which the hearing may be adjourned, the applicant does not appear when the case is called on for hearing, the court will make an order that the application be dismissed. Now, 3 is in connection to the opposite party, ex party. Now, kindly consider 106(1). The applicant against whom an order is made under sub-rule 2. This is an order of dismissal of rule 105. The opposite party against whom an order is passed ex parte under rule 3 of what rule of that rule or under sub rule 1 of rule 23 may apply. So the rules of 23 order 23 rule 1 is apply of the 6. To the court to set aside the order, and if he satisfied that the court that there was sufficient cause for his non-appearance when the application was called on for hearing, the court shall set aside the order on such grounds as to cause for otherwise. Now, the order of dismissal is stating on the base of the record. Now, if your lordship considers order 23, it says if a suit is dismissed for default.
Order 23 is if they withdraw.
Yes, withdrawal if it is done.
This is not a withdrawal. This is a dismissal.
This is a dismiss for default. If your lordship may consider it 23 months, order 23.
Why should you consider order 23 is not applicable at all?
Why I want to refer it, the possibly order 23 rule 4 says that if a suit is withdrawn without obtaining.
This is not a withdrawal, Mr. It's not a withdrawal at all. It's a dismissal for default. They were absent, it was dismissed for default.
Yes, so they have a remedy under
Order 23 does.
they have a remedy under 106.
Yes, that is the difference.
Seek restoration. Here the first issue is instead of seeking restoration, they have come up with a fresh application. Second, in the second application, they did not make proper disclosure. The affidavit disclosed in support of the tabular statement is apparently incorrect statement. Even the tabular statement disclosure made by the degree holder is apparently contrary to the record. Incorrect disclosure made. So in that circumstances, my upon submission that we have a remedy to restore the earlier one, and they cannot straight away, particularly in a circumstances appearing in the case, to proceed with this second appeal. This is nothing but an abuse of process of law. And so far the jurisdictional clause is concerned. My friend has said that this court has jurisdiction. My friend has forgotten that this court has original side jurisdiction. It has a limited jurisdiction. The parties belong, the judgment debtors are from Bangaon. There is nothing on record in the affidavit disclosing that anything falls within the jurisdiction of this court. So straight away invocation of money is as in a principal civil court. Well, we have to, the petition must disclose that something is within the jurisdiction because there is a, particularly in a circumstances where the parties have agreed that the court of Mumbai will have exclusive jurisdiction. So the principal civil court shall be in Mumbai in any circumstances. Arbitration held there, award passed there. If I would have filed here section 34, the same objection would arise. I would have faced the same objection. They would have submitted that no, this is not the appropriate forum. Go to the Mumbai court. Because this is what the judgment says. And my lord, the Sundaram Finance relied upon by my lord, this judgment, my lord, particularly considers the difficulty of the judgment debtor. It was on those circumstances Supreme Court held where the judgment debtors resides or where the asset lies or where the property is, irrespective of jurisdiction, you straight away file the case where the judgment debtors reside. So even if I consider the submissions of my learned friend, it has to be in court of Bangaon, district court of Bangaon. It can't be original side jurisdiction of this honorable court.
Let me get, yes, reflect.
First of all,
Why shouldn't it be through the district court which covers one ground?
will that be a principal civil court? That
They
won't,
reside there.
that won't be the principal civil court. I am taking this submission. It has to be a court which is 2-1E, which is a principal
One is
civil
the district court having jurisdiction over that area. This is not that. Bongaon is not within the original side of this court.
Lordship, let them show that they have any immovable property in Bongaon. Their affidavit is on record today. It doesn't show any movable property. It shows only movable properties which can be attached from before this Calcutta. And what he is saying that we have
Affidavit of asset has been filed here.
All are in
The jurisdiction question was kept open.
Lordship, the jurisdiction question was taken by them on the last occasion itself. Lordship, they have taken the money.
And the first instance when the affidavits were directed, it was not taken.
Lordship, this
Because
is
expert.
Lordship, this was an affidavit of asset and execution application. They have never appeared. There were various orders. They had never appeared.
Yes.
I don't only one line response.
No, no.
I don't think
No.
upon the decree holder.
Learned counsel for the award debtor raises an objection as to jurisdiction of this court to take up the matter and the maintainability of the execution case. First up, on maintainability, it is argued that a previous application filed for execution of the self-same award had been dismissed for default. First up, it is pointed out that both in the tabular statement as well as the awardments in the execution petition, the award holder has wrongly sought to mislead this court by awarding ABERRING that the previous execution case was withdrawn, whereas the order annexed to the application itself shows that the same was dismissed for non-prosecution. The learned counsel for the award debtor also takes the court to the relevant paragraph of the affidavit in support of the execution petition, where the relevant paragraph averring that the previous execution case was withdrawn has been affirmed to the effect that it is true to knowledge derived from the arbitrator. First up, as such, on such score alone, the present application ought to be dismissed, both for misleading the court as well as due to the bar envisaged under Order 21, Rules 105 and 106 of the Code of Civil Procedure. First up, learned counsel further points out that Section 36 of the Arbitration and Conciliation Act 1996 itself provides that the procedure applicable to the execution of a decree is also attracted in case of Section 36. The next para, as regards the territoriality of this code, as regards the territoriality, learned counsel for the award debtor submits that it is an admitted position that the award was passed in Mumbai, which was also the seat of the arbitral proceeding. So next para, also, the award debtors reside outside the territorial jurisdiction of this court in its original jurisdiction. Full stop. Such position appears from the cause title of the application itself, and as such, this court cannot come within the ambit of court as defined in Section 2 within bracket 1 within bracket small e of the 1996 Act. First of next para, learned counsel for the award holder, while controverting such arguments, cites Agyodaya নামটা দেখে পড়ুন, reported at 2022 14 SCC 417, comma, where it was held by the Supreme Court that the mere dismissal of a first execution application on the ground of default may not result in the decree holder being precluded from filing a fresh execution petition, provided it is within time. So, next para, learned counsel also relies on Sundaram Finance Limited, such as such, reported at 2018 3 SCC 622, where it was observed by the Supreme Court that an award under Section 36 of the 1996 Act is equated to a decree of the court for the purposes of execution and only for that purpose. Stop. Thus, comma, while an award passed by the arbitral tribunal is deemed to be a decree under Section 36 of the 1996 Act, comma, there is no deeming fiction anywhere to hold that the court within whose jurisdiction the arbitral award is passed should be taken to be the court which passed the decree. First up, it was further held that the 1996 Act actually transcends TRANSCENDS all territorial barriers. First up, next para, it is thus argued that as per the amendments in the present execution application itself, comma, the loan agreement was entered into within the territorial jurisdiction of the original side of this court. First up, that apart, comma, it is disclosed from the affidavit of assets of the award debtor that none of the assets lie within the territorial jurisdiction of the vicinity of their residence. First up, on such ground as well, comma, since the assets are apprehended to be at present within the territorial jurisdiction of the original site of this court, comma, the execution application is very much maintainable before this court. So, next para, with regard to the first objection, comma, as to the maintainability of this application in view of the dismissal of the prior execution case, comma, the award debtor is justified in arguing that the award holder would have done well to point out before this court in the tabular statement as well as in its amendments in the application that the previous execution petition was not withdrawn, comma, with or without liberty to file afresh, but was dismissed for default. Such omission stroke error on the part of the award holder is strongly deprecated. Next para. However, comma, such effort on the part of the award holder cannot be elevated to such an extent that it was intended to deliberately mislead the court, comma, for the simple reason that the award holder has also annexed a server copy of the previous order of dismissal in the execution petition itself and has also relied on the same. Next para, from the said order dated November 11, 2019, comma, it transpires that none appeared for either of the parties when the previous execution case bearing EC 233 of 2019, comma, was dismissed for default. Next para, the provisions of rules 105 and 106 of Order 21 of the Code of Civil Procedure are nowhere couched in negative language so as to preclude the award holder stroke decree holder to file a fresh execution case on the self-same cause of action. First up, unlike Order 9, Rule 9 of the Code, comma, where in respect of a suit, comma, the law precludes the plaintiff to file a fresh suit. order 9 rule 9 বলেছি তো 9 টা তো order 9 comma there is no such specific bar in order 21 in respect of an execution piece. So next para, it is also to be noted that even in rule 4 of order 9 comma in cases where none of the parties were present at the time of call and the suit was dismissed for default, comma, there is no bar on the plaintiff to bring a fresh suit on the self-same cause of action, even if the previous suit was dismissed for default. Question next para. Applying such principle, comma, in any event, comma, there is no bar, even in the Code of Civil Procedure, to prefer a second execution case in such circumstances. Question next para. That apart, comma, this court is bound by the proposition laid down in Abhyodaya Sutra, where the Supreme Court, comma, in unambiguous terms, comma, accepted the contention of the appellant therein that mere dismissal of the first execution application on the ground of default may not result in the award holder stroke degree holder being precluded from filing a fresh execution petition, provided it is within time. Full stop. Next para. Now coming to the question of territoriality, comma, clause 24.1 of the agreement between the parties contains a forum selection clause which stipulates that any suit, comma, petition, comma, reference or other filing permitted or required to be made pursuant to the 1996 Act in respect of matters arising out of the agreement, including without limitation, a petition for appointment of an arbitrator or arbitrators under Section 11 of the said Act shall be instituted only in competent courts at Mumbai. Question. Next para. However, comma, on a careful construction of the said clause read in conjunction with clause 23.1, comma, which subjects disputes and differences between the parties to arbitration in Mumbai, comma, it cannot but be observed that the fetter in the said clauses applies up to the award being passed in the arbitral proceeding. Next para, the filings, etc., contemplated in clause 24.1 are restricted to matters arising out of the agreement. Once the disputes arising out of the agreement culminate in an award, comma, the said restriction is no longer applicable, but the award comes within the domain of Section 36 of the 1996 Act. Para, it is well settled that in case the property sought to be attached, etc., in execution of a decree lies outside the jurisdiction of the suit court, comma, precepts, PRECEPTS, can be issued to the court where the property is lying. Borrowing the said principle, comma, in the present case, comma, an apprehension has been raised that the assets which can be utilized for execution of the award lie within the original jurisdiction of this court. That apart, comma, at least a part of the cause of action of the for the initial proceeding also arose within the jurisdiction of this court, comma, since the loan agreement was entered into with the original territorial jurisdiction of this court. Next para, if over and above the aforesaid reasonings, comma, the ratio in Sundaram Finance is also binding on this court, which clearly observes that an award under Section 36 is equated to a decree for the purpose of execution only, and there is no deeming fiction anywhere to hold that the court within whose jurisdiction the arbitral award is passed should be taken to be the court which passed the decree, and that the 1996 Act actually transcends all territorial barriers. Next para, seen from such perspective, comma, this court has ample jurisdiction to entertain the execution application between the parties. Next para. Hence, comma, the objections taken as to maintainability of the application and as to territorial jurisdiction of this court are turned down. Full stop. Which of the award debtors have to
Letter number 3, demand.
The only thing you know to consider like payment of assets. I have disclosed 3 bank accounts and 1 property, all paid in the jurisdiction of
Accounts,
not of this person, Ashok Nagar. Ashok Nagar. All are in Ashok Nagar.
money is
respondent accordingly the award debtor number 3 one is a lady.
one is a baby.
Award debtor number 3 shall be personally present in court for being examined by the award holder on August 8, 2024, when the matter shall be listed for hearing. Huh? Okay, very good.
Item number 8. Aditya Birla Finance Limited.
Yes.
Lordship of the argument in the petitioner award. Lordship, in this matter, fresh warrant of arrest used to be issued. Warrant of arrest was issued thereafter extended, but they were not produced.
It appears from the report of the Deputy Sheriff dated June 9, 2023 that the warranty has been absconding since long and no information could be obtained in that regard. No, in that regard, no information could be obtained with regard to his current whereabouts. Question next para. Accordingly, on the pair of the award holder, a fresh warrant to issue for personal production of the award debtor before this court for being examined by the award holder on August 29, 2024, when the matter shall next be listed. The officer in charge of the concerned police station and the concerned commissioner of police shall ensure that the warrant is implemented duly. Requisites shall be put in for such fresh issuance of warrant by the award holder by tomorrow.
Item number 9.
Matter there were
Refused.
there were delays to file an attribute or asset. 1 year has already passed, but they have not
One?
filed it. 1 year.
1 year.
Last 9 June. They have not filed the attribute.
That is your affidavit of asset. An adjournment is sought on behalf of the award debtor. However, it is seen from the order dated June 9, 2023, that the award debtors were directed to furnish their affidavit of assets more than a year back. However, till date, no such affidavit of asset has been filed by the award debtors. Even today, an adjournment is sought, which makes it evident that the award debtors are attempting to elude the process of court. According which of the award debtors should be present?
Warrant upon the respondent number
My lord, I am appealing for the respondent
Has
number
been
2 and 3, my lord.
Not that right now, there are numbers. Accordingly, as a last chance to the award debtors, the award debtors are directed to file their affidavits of assets by August 1, 2024. The award debtor number 3 shall remain personally present in court on August 8, 2024 for being examined by the award holder. Next para. Advance copies of the affidavits of assets shall be handed over to the learned advocate of record for the award holder sufficiently prior to the next returnable date. It is made clear that in the event the award debtor 3 is absent on the next occasion when the matter is called on for hearing, appropriate orders for issuance of warrant of arrest shall be issued.
Item number 10, yes.
Also, in this matter, warrant was extended, so I am taking of issuance of fresh warrant of arrest upon the respondent number 2 and 3.
You have to file fresh requisites. On 9th of June, that direction was given. That was for extension of the warrant. No report. 9th of June, 26. Written.
Four items per item.
Very well. On the prayer of the award holder, since the award debtors could not be produced till now, pursuant to the previous warrant of arrest, a fresh warrant of arrest to issue for production of the award debtors on August 29, 2024 for being examined by the award holder. First up, the concerned officer in charge of the officer in charge of the concerned police station and the superintendent of police having territorial jurisdiction in the area shall ensure that the warrant is duly implemented. First up, the award holder shall put in few requisites for such fresh issuance of warrant by tomorrow. So, in the meantime, the deputy sheriff shall furnish a report which will be placed on the next occasion before this court, indicating as to the outcome of the previous warrant, as well as the outcome of the fresh warrant which is to be issued today. So, both such reports shall be produced by the next written report.
Warrant number 2 and 3. Warrant number
Order respondent by 2 and 3. Okay. Respondent number 2 and 3. 29th August. Yes, next. Item number 11.
matter but they are not filed their application. And praying for dismissal of fresh warrant of arrest upon this.
None appears for the award debtor at the time of call. Award debtors at the time of call. It transpires from the order dated May 19, 2023 that the award debtor number 3 was produced in court pursuant to a previous warrant and undertook to file Vakalatama for the department. The directions for affidavit of assets were also previously filed, but not complied with by the award debtors. Accordingly, a fresh warrant of arrest to issue for personal production of award debtor number 3 on August 29, 2024 for the purpose of examination by the award holder, the officer in charge of the concerned police station and the superintendent of police having jurisdiction in the area shall ensure that the warrant is duly implemented. The award holder shall put in requisites for such fresh issuance of warrant within 48 hours from now. The matter shall next be listed on August 29, 2024.
Item number 12.
That does not create any extra right in the table. Yes, what is the matter?
Fresh requisition. There was talk of settlement, so we did something and take for fresh warrant of arrest.
Take instruction, ma'am, whether there is any chance of settlement. I'll keep it there. That depends on you, but I'll give you that liberty. But you take instruction whether settlement is possible. Yes. The award learned counsel having instruction to appear for the award debtors on change seeks 2 days adjournment to file her Vakalatnama. Such leave is granted. Next para. The award debtors shall file their affidavits of assets by August 22, 2024, when the matter shall next be listed under the same heading. Advance copies of the affidavits of assets shall be handed over to the learned advocate and record for the award holder in the meantime. Full stop. Next para. It is made clear that nothing in this order shall preclude the parties from arriving at mutually negotiated settlement in the meantime. Full stop. However, comma, pendency of such settlement shall not per se be an excuse for the award debtors not to comply with the direction given above. Please ask you are being led by somebody. Please ask him or her to check up the order, the contents of today's order. Yes. Next.
Item number 13. Tata Capital Fund Service.
Lordship,
What was the stage of the matter?
taking supplementary affidavit.
Of asset.
Supplementary affidavit.
Disclose bank account.
Yes, Your Lordship. The statement of account.
That has been filed.
Yes, Your Lordship.
Switch on the mic.
Lordship has already heard of this matter last day, Lordship. Lordship, July. Lordship, I expect the examination of the judge.
Oh yes, where is the judge?
Your Lordship, I am challenging.
He had to be present here.
He's here, Your Lordship.
Let the examination start. Did you take the identity point previously?
Lordship, Your Lordship has passed a judgment, Your Lordship, stating that since there is an option for waiver, it is not void ab initio. It's a unilateral appointment, Your Lordship. But in my respectful and humble.
So you want to challenge the section 30?
36, Your Lordship.
You did not take that challenge at any point of time.
Your Lordship, I had filed a section 34, Your Lordship, but it was dismissed from the point of limitation since, Your Lordship, I did not receive the award, Your Lordship. I had only come to know of the award after the second time the execution application.
So then why did you take the same point in the execution case also?
Your Lordship, we were directed only to
There were several directions. This direction exercise is going on from, I'm telling you, from 21st of September 2022. You never took the point of maintainability. I won't let you do that right now.
Your Lordship,
Give the examine here.
there was only a direction to file the supplementary affidavit bringing on record the payment, Your Lordship. And that has been filed, Your Lordship.
No, you did take the point of maintainability. You are not aware of your own matter. 6th September, you have taken that point. Let us see what happened to that. The court has to point out to you what point you took before the previous. This is ridiculous.
Time of proof that they were saying that Lordship,
Please come. Have you got a copy of the 6th September order? You don't. You had raised a point of maintainability on the ground that award was received by you on 22nd of October 2020. But dates said otherwise. The petitioner says otherwise. That was recorded. According to them, the award was delivered to other persons who are not the award debtors.
Lordship, it was not delivered to us, Your Lordship. It was delivered to a wrong address, Your Lordship. All this points that
Yes.
34.
In section
34,
36,
Your Lordship.
you took this point in the section.
Yes, Your Lordship.
In this section 36, have you taken the point ever? This was taken by you. Then
Yes,
this is the factual aspect of the matter. Then you are directed on this, the court directed you, respondent one, to file an affidavit clarifying whether handwriting appearing at page 73 of the application bearing the PIN code is that of the petitioner and the respondent. Did you file an affidavit to that effect?
Yes, Your Lordship.
What did you say in that? You are not prepared in the matter, ma'am. Learned counsel for the award debtor is not fully prepared in the matter. Full stop. The said learned advocate is requested to prepare herself in the matter properly and return on August 8, 2024, when the matter shall next be taken up for hearing. Please go through the order sheet. Please furnish her with the order dated 9th of September. You can take out a printout. Take out a printout of the order dated 9th of September 2023 by Justice Mokhi Bhattacharya. 6th of September. And if you have a copy, give it to her. Go through that. Go through your affidavit. And then I'll decide whether I permit you to argue on this. Because if you have taken this point, this is a factual aspect, right? You say that it was delivered, they say it was delivered at your address, probably they must be saying, last known address. Somebody else accepted on your behalf. You're denying that. If you do that, then it's clearly a factual dispute We have to decide on affidavits. If you have filed an affidavit, I'll decide that first and then take it. Then they have taken this point. You should also have pointed out. Both of you come prepared in the matter. Remind me on the next occasion, this was the reason why I adjourned. Yes. Next.
Item number 14.
Yes.
Matter also they have surrendered but not yet filed their affidavits and praying for issuance of coronavirus.
By an order dated June 5, 2023, the award debtors were directed to file their respective affidavits of assets and serve copies of the same upon learned counsel for the petitioner within 6 weeks from that date. Full stop. Next para. At that juncture, the award debtors had been produced in court pursuant to a previous warrant of arrest. Full stop. Till date, however, no affidavits of assets come forth, F4PH, come forth from the award debtors, which is in direct contravention of the order dated June 5, 2023, full stop. Hence, a fresh warrant of arrest to issue for production of both the award number 2 and 3. For production of award number 2 and 3 on September 5, 2024, when the matter shall next be listed under the same heading. First up, the officer in charge of the concerned police station and the superintendent of police having territorial jurisdiction shall ensure that the warrant is duly implemented. First up, the award holder shall put in the requisites for issuance of such fresh warrant within 48 hours from now.
Item number 15.
Yes. You have given a copy. You should have given a copy earlier. Come back on 8th of August with the affidavit of assets. So if you want an examination, I can fix a date also for that. Or would you like to take instruction on this? That in any event that will happen. Please ensure which of the award debtors will appear. Very good. Yes. The affidavit. What about 1 and 2? Yes, company and a lady are not required to file their affidavits. 1 week. The affidavit of asset filed on behalf of award debtor number 3 today we kept on record. First up, a copy thereof is served here and now on the learned advocate for the award holder. First up, next para, the time for filing affidavits of assets by the respondent number 1 hyphen company and the respondent number 2 is extended for a week from date. First up, advance copies of such affidavits of assets shall be served on the learned advocate record for the award holder also within a week from date. Full stop. The matter shall next be listed on August 8, 2024, when the award debtor number 3 shall be personally present in court for being examined by the award holder. Full stop. Since the award debtor number 1 is a company and the award debtor number 2 is a lady, no direction. Why shouldn't the lady also appear? Do you want to examine the lady or? The last sentence again. Since good. Please comply with this so that we can proceed with them. Thank you. Next.
Item number 16.
Yes.
Matter warrant was extended, but they have not been served. And paying for fresh warrant upon respondent.
It transfers from the report of the Deputy Sheriff dated August 4, 2023 that the flat of the warranty was under lock and key and the warranty had apparently left his residence and his present whereabouts would not be traced out. Accordingly, the award holder shall put in fresh requisites within 48 hours for issuance of fresh warrant. A fresh warrant of arrest to issue for production of which award debtor? Of award debtor number 2 on September 5, 2024, when he shall be produced personally in court for the purpose of examination by the award holder. Next para, the officer in charge of the concerned police station and the superintendent of police having territorial jurisdiction in the area shall ensure that the warrant is duly implemented. Full stop. Yeah, business. Yes.
Item number 17.
Was the warrant was extended? Which warrant upon this?
3. Same order হবে শুধু award data number 2 এর মধ্যে 3 হবে report data. Yes.
Item number 18.
Matter pursuant to the last direction. It has been delivered upon the respondent numbers 2 and 4 and praying for issuance of warrant of arrest upon this.
The affidavit of service filed today be kept on record. None appears for the award debtors despite service. Full stop. Accordingly, a warrant of arrest to issue for personal production of award data number 2 on September 5, 2024, when the matter shall next be listed. Full stop. Oh, the officer in charge of the consequence.
Item number 19. Tata Capital Finance.
You're not using the microphone.
The award debtors 2 and 3 has appeared in person for the last 2 days.
You have 2 or 3? 3. So what do you want now? They have to file their affidavits of assets. Yes, you are ready with the affidavits?
My lord, as per the last order, I have already sent a letter to the ex-advocate and he has provided us with the LC. And my lord, in the meantime, we have prepared a draft affidavit of the assets. You can check, my lord.
No, the NOC is not there. Yes.
Yes.
No.
My lord, see also.
So you have to file the.
Yeah, my lord, I need some time to engage an advocate and file. That's my.
You have got sufficient time, sir.
My lord, actually, I got the LLC late, that's why.
When did you get it?
My lord, it was signed on 11, I got it on Monday. Yesterday it was a holiday, my lord. My lord, so everything is ready.
Not yesterday, day before yesterday. Or yes. Well, so I'll give you 1 week's, 1 week's time. You will affirm your affidavit of assets, serve a copy on them, and keep it after on 8th of August. You want to add something?
But there is one more case, you can complete this one.
I get your permission. No, wait, you're right. You're right. You are number 3, you say. The award data number 3 appears in person and seeks some time to file the no objection Bagalatama as well as the affidavits of assets as per previous direction. So next para. Accordingly, the award data number 3 is permitted to file Bagalatama to represent himself as well as the award data number 2 and as well as the other award daters. The affidavits of assets of award daters number 2 and 3 shall be affirmed within a week from date, and advance copies of the same shall be served on the learned advocate on record for the petitioner stroke award holder within a week as well. Next para, the matter shall be listed on August 8, 2024, when the award data number 3 shall be personally present for being examined by the award holder. The very next matter is yours. You are Mr.
My lord, there is one more case, serial number.
You are Mr. What is your next? Mr. Pati, yes. What is your next matter?
My lord, there is one more case, serial number 11, EC 324.
I've already passed it on.
My lord, I don't actually, my same advocate didn't appear there also. I will file the affidavit for both the
So
together.
you'll have to wait either I've passed an order in open court, so I cannot recall that. If I have issued a direction of a warrant to be issued, then you'll have to wait for the warrant. Otherwise, you present yourself personally on the next day, I'll pass orders.
My lord, I will file the affidavit for both together.
You don't require a leave for that. Not affidavit. Wakalat now. Please check the website for what order has passed in that. Yes, comment next.
Item number 20.
Time of hearing to the award holder, the judgment letter number 2 was examined in part. We had asked for some
Documents should present.
documents to be written.
Yes, what about the
My lord, I have the documents, but they have not been affirmed. But he has brought the documents today in the morning.
documents were to be for the purpose of examination? Where is the judgment written?
Lordship, my instruction was also there that there is some kind of settlement steps being going on.
Very good.
So Lordship can keep it on 8th of August, right?
Very good. Do you want copies of the documents? Should I record that you are handing over? These are the copies. Yeah. The documents directed to be produced by the award data number 2 are sought to be produced in court, and copies thereof are handed over to the learned advocate for the award holder in court as well. Which the next para, learned counsel for the award holder, comma, at this juncture, comma, submits that the parties seek to explore the opportunity of mutual settlement out of court. Such uh, effort is welcome. So accordingly, the matter is adjourned till August 8, 2024 to ascertain whether the matter can be settled between the parties.
Item number 21.
Judgment letter number under arrest, but they have not filed their wait for issuance of order.
No, the last order was 2nd March 2022. Oh, so that one. What the order for that? 2nd March last order. No, but all the orders should be there in the file. Principal order नहीं था. Department is not. Order.
The judgment letter number
Oh, अच्छा, very good. A copy of the order dated May 15, 2023, passed by a coordinate bench, is handed over by learned counsel for the award holder, which indicates that one of the award debtors, namely Mr. Anand Gupta, had been produced in court and was directed to file affidavit of assets as well as to be present in court on the next returnable date for being examined. First of next para, it is submitted that neither the affidavits of assets were filed nor the said award debtor presented himself in court thereafter. First up, even today when the matter is called on for hearing, comma, none appears for the award debtors. First up, accordingly, a warrant of arrest this is a fresh warrant. A fresh warrant of arrest to issue to ensure personal production of Mr. Anand Gupta. Is the award debtor number?
is file number 2.
The award debtor number 2 on September 5, 2024 for being examined by the award holder. The award debtors are directed to file their affidavits of assets within a fortnight from date with advance copies to the award holders. Server copy of this order shall be communicated by the learned advocate for the award holder to the award debtors to ensure compliance. Warrant of arrest plus server copy by whatever mode, file an affidavit of service.
Item number 22.
Matter warrant of arrest was issued upon the respondent have not filed their affidavit of asset, rather they have appealed.
Yes, I require a report. Where is the sheriff? Report. Not leaving log and key. So what do you want?
Compact practice
The report of the deputy sheriff dated August 23, 2023 indicates that the warranty has not been living at the last known address for a long time and the house is under lock and key. Learned counsel for the award holder seeks time to ascertain the current address of the award debtor. First of for such purpose, comma, the matter is adjourned till August 8th, 2024, when it will be listed under the same heading. Should I extend the arrest warrant in the meantime? The warrant issued earlier is extended till August 8th, 2024. Then you have to deposit fresh requisites. Fresh requisites for such purpose shall be put in by the award holder within 24 hours. Do it within 24 hours.
Item number 23.
What will this matter of warranty pending, thereafter name of the award holder has been filled, we have filed an application. The amendment part has been done, madam, but the reaffirmation is pending. I am praying, madam, to consider this order passed by the, dear madam. Praying for 2 weeks time for reaffirmation of the amended institution.
Very
If before that I got an order, madam, we have to complete.
The amendment has been carried out.
Amendment has been carried out, only the reaffirmation is pending.
Although the amendment has been carried out with the cause title regarding the name of the present award holder. Award holder,
Award holder, my
Present-
earlier name was Poonawala.
present award holder, comma, reaffirmation of the affidavit has not yet been done, full stop. Accordingly, necessary formalities regarding the reaffirmation is directed to be completed within a fortnight from date. The matter shall be listed on August 8th, 2024, under the same date. Thank you.
Non-commercial division. Non-commercial. For the examination of judgment letters.
What? এটা আমার ডিস্ট্রিবিউট করা আছে
Item number 5.
Lordship, I'm appealing to the award holder, Lordship, by an order dated 4th July 2024, where the sheriff had filed the report. The address that we had given, the report had come that he is not residing here. Lordship had given us time to get a new address where he is residing. Lordship, we have got the,
I'll keep it on record and direct it to,
Lordship, the warrant of arrest has to be now executed on this new address.
yes, but you also have to put it in your, I can do the two simultaneously. I'll give you liberty to amend the procedural of this also. Just add the current address. Don't delete the previous one.
Also residing.
Currently, ever included. Fresh warrant have a process. The learned counsel for the award holder submits that the award holder has ascertained the current address of the award debtor. Award debtor number? Award debtor number 1 in the meantime, and hands over the printout of an email to that effect, which is kept on record. Full stop. Accordingly, a fresh warrant of arrest to issue for personal production of the award debtor, comma, at the current address on accordingly, a fresh warrant to issue at the current address as furnished by the award holder for personal production of the award debtor number 1 on September 5, 2024, when the matter shall next be listed. The learned advocate on record for the award holder shall carry out the necessary consequential amendments in the cause title of the execution application to incorporate the current address of the award debtor as well, comma, full stop. The necessary reaffirmation shall also be completed accordingly, full stop. The entire process shall be concluded within 4 weeks from date. The award holders shall put in fresh requisites for the issuance of fresh warrant of arrest within 24 hours. Within 24 hours.
Item number 6.
This matter was handed over to
Yes. Apart from time, anything else? Apart from adjournment, you may ask anything.
Arthur.
No passport. What is the matter about?
Lordship, in this matter, the asset had been handed over to a third party, which is recorded in various orders. Lordship, on the last occasion, had asked us to communicate the orders to Taposh Rao, who is the third party, as well as award letter number 2, which we have done, Lordship. This is a affidavit of service.
You are appearing for the award debtors.
Lordship,
For the third party.
Third party.
You are the most important party now, so I have to give you adjustment. Pass over for how much? How long? Who is your senior? Affidavit of service filed to be kept on record. Full stop. Let the matter stand over till August 8, 2024, since an adjournment is sought on behalf of the third party, Taposh Rao, with whom the asset is now lying. Full stop. It is made clear that no further adjournment shall be granted to the third party or the award debtors when the matter is called on the next returnable date. Ma'am, please inform your senior that on the next date you have to come prepared and Mr. Taposh Rao should be present in court. I'm not directed, but should be present. Yes. Item number 7. Award debtor. Yes, what does the award holder say? Yes, where is he? Ask him to come to the room. Post tender. What direction? Tell me. Furnish bank statements.
Yes. So back and back. In case my lord has.
No, he did not furnish this.
That was the order.
Yes.
So
What about the further particular bank accounts? I got a 4th July. There was an order dated. There was an order dated 4th July, which directed you because they alleged that the affidavit of asset does not disclose the particulars of the bank account.
and where, yes, within certain bank, but there are incorrect account numbers, incorrect address, incorrect branch. We are receiving several notices from several branch that this is not our account. That's why I did.
Then do this. I'll grant you liberty to file an affidavit. You disclose what is the basis of your saying that these particulars are not. Because you're saying something, some communication, something.
I will annex all the documents which I have received from
I think so.
bank.
I think so. You annex those documents. You do that by August 8th, and on August 8th, I'll request your client to come in. Or should he be present on the next day? Where does he come from? How is it already?
Let's say, yesterday or Thursday.
Then he need not come on 8th of August. You file an objection, give a copy to him.
I will file an affidavit.
Arunachal Pradesh.
I will file an affidavit.
Can he come on next on 22nd of August? Just ask him. Well, I'll relieve him on the next date. I'll take it up on August 8th. I'll see their affidavit and you have to answer to them.
He himself has disclosed 4 bank accounts. Let him disclose the bank statement. That's only my prayer. Because I have already.
But you also put it, whatever you're saying, put it on note so that everything is on record so that you can proceed on that. The award debtor, is the award debtor number? The award debtor is personally present in court. Next para. However, it is seen that no particulars of bank statements, no particulars of bank accounts and or bank statements have been produced by the award debtor as per the previous direction dated July 4, 2024. Next para. Learned counsel for the award debtor submits that the particulars have been disclosed in the affidavit of asset itself, which is denied by learned counsel for the award holder. It is submitted by the award holder that
I am not denying. It's saying that it's not sufficient.
The counsel for the award holder. No, she says sufficient address. Let me copy my order. The counsel for the award holder submits that the particulars disclosed in the affidavit are not sufficient, and the bank statements of the respective accounts would reveal the actual details. Next para, that apart, contradictory communications are being received by the award holder, which indicates that the full particulars of the assets of the award debtor have not been disclosed. So next para, the award holder is, thus, directed to file a supplementary affidavit disclosing the circumstances due to which the award holder is insisting that all particulars have not been disclosed by the award debtor in its affidavits of assets, also annexing relevant documents, communications to such supplementary affidavit in that regard. So next para, such affidavit shall be affirmed within uh, a fortnight from date, and an advance copy of the same shall be given to the learned advocate for the award debtor. So, sir, the award debtor shall act on such copy, and before the next returnable date, shall furnish further details along with the bank statements of the accounts already disclosed in the affidavit of the asset, and file the same on the next returnable date. Advance copies of such affidavit and documents shall also be handed over to the learned advocate for the award holder. The matter shall next be listed under the same heading on August 22, 2024, when the award debtor shall be present personally as well. So, do you get the point? They will disclose why they are saying, and you will, in any event, even if they don't use that supplementary affidavit, you have to disclose the bank statements of these accounts, current bank statements, and further particulars with the point of. So let us disclose whatever, so that we cannot have any cons on that, and you can also tender those documents. I mean, I don't need to advise. Yes. Article number 8. The banking debt.
This is my execution application. The document letter number 1 had expired. We had substituted this legal S. Lordship had thereafter passed an order on 5th of July for them to file their affidavit of assets.
I already filed the order number. Today I filed the affidavit of asset.
Copy.
I want to file the application continuity or not. Because my lord, December 2011. Hereafter, my lord, judgment division number 1 died on 6th April 2012. And the arbitration proceeding start and awarded my lord since April 2014.
Hearing of the arbitral proceeding was concluded before the death.
Before the after that.
When was the hearing concluded?
When concluded and award passed in place.
When was the hearing concluded of the arbitration?
And at 10th April 2014.
10th April the hearing was concluded, or the award was passed?
Award was passed.
10th April award was passed. When did it die?
2014.
14. When? Then you have to file an affidavit also. Do that within a week.
Address used by the petitioner, my lord, is not my address.
Take all your points in your affidavit in opposition and give it that.
This we have a 3 weeks time, my lord. Actually, it's
I'll give you 3 days. What 3 weeks?
But the
Give it within 3 days.
but lady is residing Bihar, my lord.
The gentleman is standing before me.
No, my lord.
You will draft, send it to him.
Other 2 is my lord.
I'll give you, I can at best give you 1 week. Bihar, how long does it take to come? Should I ask my orderly right now?
No, my lord, that's not.
I know very well how much time. Where in Bihar?
Vaisali.
Vaisali. How long does it take? Overnight.
No, but my lord, required.
What required? Nothing required. The affidavits of assets filed by the, you are the substituted award debtors. The affidavits of assets filed by the substituted award debtors in place of original award debtor number 1 today be kept on record. So copies thereof shall be handed over to the learned advocate for the award holder. Shall be and are handed over to the learned advocate for the award holder here and now. Push up next para. Where a counsel for the award debtors raises an objection as to maintainability of the execution fees on several grounds, comma, some of which are linked with factual averments. Push up. Accordingly, the award debtors are directed to file their affidavits in opposition to the execution application. I'll give you a fortnight's time to within a fortnight from date, Pushta, reply if any shall be filed before the next returnable date, Pushta. The matter shall be listed next on August 8, 2024. 2024. Did I direct him to appear personally? Not yet then. I'll first decide this question. On August 8, 2024. Item number 8.
Worship, judgment letter had 9. Worship, the judgment
Judgment
letter had to be present for examination.
Yes. You are the judgment letter. Go to the books.
Well, it will not be judgment letter.
Where is he?
Well, actually, the judgment letter is decided in Haldia, and yesterday was Muharram, and they are Muslims. Therefore, my lord,
So you are saved.
my lord, no, my lord, that point. My lord,
Yesterday was Bahram. He is Muslim.
my lord,
Leave it on your lordship.
my lord,
Why is he not here today? Yesterday Bahram, I also know.
my lord, the reason is, my lord, they had filed the evidence of assets. They were,
Why is he not here today, sir? Why should they issue a warrant of arrest?
my lord, on that account, my lord, because, so,
He is a Muslim. Yesterday was Muharram.
that is,
Today there is no Muharram. Why isn't he present in court today?
my lord, that is the reason that the travel things from Haldia is of about 120. My lord. And the reason, since it was Muharram, we couldn't have the transport. And even the local trains were. But however, my lord, I shall indicate, my lord, nothing left to be cross-examined. But the reason is, my lord, the affidavit of assets that we have filed.
How can you decide what they examine?
My lord, actually sees the.
You are nowadays our auditors are deciding whether anything is left to be examined. I'm sorry. Anyway, learned counsel for the award debtor appears and submits that the award debtor could not be present in court today since he is Mohammedan and yesterday was Muharram. Pushta. Next para, however, comma, such ground does not explain as to why the award debtor could not be present today. Pushta. Next para, in any event, comma, since an adjournment is sought, comma, as a last chance to the award debtor to be present in court for being examined. Examined further. He was examined.
Examine.
For being examined, comma, the matter is adjourned till August 8, 2024, when it will be listed under the same.
Well, standing prepared.
Why your question?
My lord, the award was served, not served upon us. The award was served
So that they
upon.
have.
Did you appear on the last occasion?
My lord, I did.
Did you take the point of maintenance?
No.
My lord, on that
No.
point.
I'll take up the next matter after it comes. Item number 10.
What was? We have very in my suspicion from few accounts you said money has been transferred to the judgment number two.
When you put the questions, you may put the questions. When you put the questions, if you have any objection, take the objections.
There's nothing.
If I feel that there is relevance, yes.
See what he is asking.
So there may be relevance because if that strained relationship.
What was happened to us? Actually, yeah. Nothing with respect to character.
We'll decide that if it's not too personal. I mean, divorce, if the divorce is on paper, then it's public record. So there is no difficulty, no sentiment attached if please ask a question on that. If it has relevance only, then I'll permit. Otherwise, if you take objection, I feel it's relevant objection. You may
have character, nothing.
just no, you may ask. Yes, yes. If it has bearing, yes.
What steps have you taken in respect of the Jadavpur police case number 464 of 2009 initiated by you against Mr. Shahjahan Mullah? FIR was
No, let him answer the question. Please don't disturb. Please ask him to speak on the microphone. No, I can't hear him. The microphone is not functioning. He has to be heard by the board also.
Babuddin Khan ছিল তিনি বারবার ম্যাজিস্ট্রেটকে রিকোয়েস্ট করেছেন cancel the bail taken into the custody of police. উনি আমার গাড়িটা নিয়েছিল ভাড়াতে বেল তো আজকের আমার কেস থেকে পুলিশকে পাঠিয়েছে ছিল এমপিএস লালবাজার ছিল ইনভেস্টিগেশন দ্য ম্যাটার
Back to the police. Back to the
when was the last occasion that you had caused your advocate to take steps in Jadavpur case number 464 of 2009?
দু হাজার তেইশে অসুস্থ হয়ে 2023 আমি বলেছি লাস্ট
As you have indicated in your affidavit of assets that you by occupation carry on a business. What business are you carrying on as on date?
Our home delivery.
I run her at my house. I take it and also I
As you have proposed in your last answer, what address is this business being run from?
Calcutta. Yes, sir. 156.
Are you the owner of this house?
No. You're the shareholder.
I'm a shareholder.
No should also. No,
No,
I'm a
no.
should.
Who are the co-owners of this house?
Two sister. I. Their child.
Are you also a co-sharer of property situated at 155, 154, 153, and 152 Dhalipara Chittaranjan Colony, Police Station, Jadavpur?
Yeah.
Who are the other co-sharers of such property?
Our sister. The cousins.
And other property.
How many co-sharers in totality are of this property 155, 154, 153, and 152 Dhalipara?
About 10 to 12.
Call upon you to produce the title documents or title deeds of 155, 154, 153, and 152 Dhalipara, Chittaranjan Colony, Police Station, and Post Office, Jadavpur, and 156 Dhalipara. Say, Chittaranjan Colony, Police Station, and Post Office, Jadavpur. On the next one.
It's a joint property. How can we?
Please don't suggest. Please don't suggest any answer. Otherwise, I'll put you outside courtroom. Who told you to suggest the answer to the witness? Please, a second. At a recording, bracketing. At this juncture, learned counsel for the awarded seeks to suggest answers to the questions put to the witness. Push-up, such practice is deprecated. Push-up, learned counsel for the awarded is restrained from repeating such act further during the examination. Bracket closed. Please continue.
পাচ্ছি না, আমার লোনও পাচ্ছি না, কিন্তু আমরা জানি।
Those titles are not available to the offer. So they all are with this. Lifetime of my where they the titles not have any knowledge. So it is not
Something with respect to the loss of these title documents as deposed by you.
আমাদের ভাই বোনের ওদের সাথে আলোচনা হয়েছে, আমাদের সরকার যায়নি, ভালোভাবে ওই জন্য আমরা এখন প্রসেস করি। আমাদের আমরা সবাই এখন একভাবেই আছি, আমাদের কোনো ভাগ করতে আমরা করিনি।
as of now there is no party property. We are having discussed higher along with my not to our studies and take on other problems.
When was the first time that it came to your knowledge that the title deeds of such properties are missing?
বাইশে আমরা বুঝেছি মা মারা যায়, তারপরে আমরা দিয়েছি। মা মারা যাওয়ার সময় কোথায় রেখে গেছে সেটা আমরা জানি।
After the death of my mother, what happened? I know the title was always
না, আমরা কেউ পাইনি।
Have you initiated any proceedings for declaration or injunction of any of the aforementioned properties?
আমাদের যে আদার্স প্রপার্টি আছে আমরা কোর্টে জজ কোর্টে সেটা
I have I have for injunctions. But there is other problem.
অন্য
When you depose other properties, can you please tell my lord what these other properties are?
বাড়ির সাথে লাগানো মানে 150 অ্যাড্রেসের
They are also under this, the one adjoining to
নেক্সট
our
নেক্সট ওয়াল
adjoining to our the property which was
I call upon you to produce the cause papers filed in title suit number 387 of 2013 by you on the next one. In your estimate, how much are the properties valued which are the subject matter of title suit number 387 of 2013 filed by you before the learned first civil judge, junior division at Alipur?
what is that? The total about 30.
Are you aware of where the judgment debtor number 2 as on date resides? Miss Sheila Noshkar.
I
after paying to issue the title. The
You
title
want to resume on the next day?
yes, possibly recently writing for my realization.
Maybe we'll keep it on 8th of August. We'll keep it on 8th. The order. At this juncture, recorded. At this juncture, after partial examination of the witness, learned counsel for the award holder seeks to put further questions to the witness on the after getting the documents.
Yes,
After getting the documents which the witness is to produce on the next occasion. So accordingly, let the matter stand over till August 8, 2024, when the witness shall produce the documents which he sought to produce in answer to the queries put to him.
subject to my lord sign. So the document
Very advance copies of the said documents shall be handed over to the learned advocate for the award holder within a week from date. What are the documents? Please specify to a learned advocate. Only those. You refer to the suit papers, probably? And did you refer to title deeds also something?
he said it does not help, so I cannot.
Very well. Thank you. Next.
Item number 11.
After the award letter had to be present.
Actually, in the previous matter, please tell him the witness should be present on the next date also. I'll put that in my order if I have not. Yadi na diye tha ki the witness shall be present in court on the next written appeal. Please tell him. Oh, yes.
Lordship, the award letter had to be present for examination. The affidavit of assent has been filed.
What is it? There was a specific direction on 4th of July.
Yes, Lordship, and
I have
there has been already warrant of arrest against him, which could not be executed because he was shown as absconding. He had come and
Where are the papers? Give copies to her. All right, put that in by way of an affidavit. Keep it with you. Put that by way of an affidavit. When can he come? 8th of August. Keep it. Very well. But put those on affidavit and file it on the next day with the advance copy. Learned counsel for the award debtor seeks an adjournment on the ground of serious ailment of the award debtor. On query of court, learned counsel for the award debtor also seeks to produce documents to substantiate such claim of serious ailment of the award debtor. The award debtor shall put in. The award debtors shall put in such documents by way of annexures to a supplemented affidavit, which shall be filed on the next returnable date, with advance copies thereof to the learned advocate for the award holder. Since learned counsel for the award holder submits that the award holder would be able to present himself in court on August 8, 2024, the matter shall next be listed on the same date when the award debtor shall be personally present in court for examination. But please ensure that it comes on that.
item number 12.
After the affidavit of assets of award letter number 1 was already in record, the award letter number 2 was directed to file as affidavit of assent. We have served upon both judgment letters and both have received, but they are not present today for the examination.
Then I'll have to issue the award letter 1 was examined completely. The award letter number 1 was examined on December 4, 2015, partially. So subsequently, the award debtors were to be present in court for being examined. So, however, today when the matter is called on for hearing, none appears for the award debtors, nor are the award debtors present in court for being examined. Full stop. Accordingly, line. As per previous direction, dated July 4, 2024, notice of the next returnable date, that is today, was given to the award debtors. Full stop. Affidavits in opposition to that effect filed today be kept on record. Full stop. Since the award debtors are deliberately avoiding presence, warrants of arrest to issue to compel the personal presence of personal production of the award debtors on September 5, 2024, when the matter shall be listed under the same heading. The officer in charge of the concerned police station and the superintendent of police having territorial jurisdiction in the area shall ensure that the warrant is duly executed. Due requisites to that effect shall be put in for such issuance of warrants by the award debtor within 48 hours.
This has gone as executive composition. Effective service.
Thank you.
Item number 13.
Should be this matter.
Yes.
There was a box of
With adjourned for
Item number
no, not difficulty. What about stocks of settlement?
My clients are paid 1 lakh, they have said that 5 lakh. And I have went on telling them that they settle for them, hope for them. Otherwise, they will have to come and suffer the consequences.
What do your clients do?
My lord, one is this current worker. The older gentleman is a retired person. They live in a rustic village of Uttar Pradesh, near Fateh. Now, my lord, the son is working in a private school, getting a salary of bigger salary. This is what, as I told them, they have
Evidence of asset you have filed?
we have filed. That we have filed. My fortunate of this honorable person. But my situation is such that they are villagers. And they are from a small village in Fatehpur district of Uttar Pradesh.
They had taken a loan. At that time also they were villagers.
Finally not given.
So let them come for example.
Let them come. But I'm not saying Millard.
No,
Whenever has been shown Millard has been shown to them. You will buy the Millard.
I'll give it on 22nd of August. 22nd of August.
Millard 22nd of Millard after 20.
29th. Upon hearing learned counsel, it transpires that the talks of settlement has failed between the parties. Accordingly, the award debtors shall be personally present in court on August 22, 2024, when the matter shall next be listed under the same heading, for being examined by the award holder. Both the award holders debtors will be presented. Talks of settlement as which you have talks. Next. 22nd. 22nd August, next week.
Second
29th. He said he has difficulty. By mistake, it went down as 22nd, it will come on 29th. He's in front of your other side. She is your other side. 29.
Item number 14.
Can't hear you. That is the first problem.
The lordship's last direction. So is order, last order.
Yes.
Either judgment number 1 examining part. While examination, my lord, yes, disclosed that he has given the consent to his father, who has sent the asset to Nepal. So, my lord, I will take only half an hour or make between 20 minutes to my lord, initial process.
So, auditor number 1 was to come for
Yes.
further review.
Yes.
It is
And
not.
my lord, the advocate has received my lord. All these matters, whenever they are coming, they have given sort of sort of could be directed.
That is the issue. Then I have to issue for interference.
Yes, sir. But there, Calcutta.
Despite service of notice, comma, which is borne out by the affidavit of service, which is filed today and kept on record, comma. The award letter number 1 is neither present nor represented when the matter is called on for hearing today. So accordingly, a warrant of arrest to issue for personal production of the award letter number 1 on August 22, 2024, when the matter shall be listed under the same heading. August 22 early September 5. September 5, 2024, when the matter shall be listed under the same heading, question. So, the officer in charge of the concerned police station and the superintendent of police having territorial jurisdiction in the area shall ensure that the warrant is duly implemented. First, due requisites shall be put in by the award holder by 48 hours.
Item number 15. Plan limited.
Settlement. What happened to the settlement? It has been successful.
25 lakhs for 9.
Whatever. If you don't agree, I cannot.
The outstanding on 9 crore. Is 1 crore 12 lakhs 40.
So they are willing to pay how much?
Their proposal, let them come with a fair proposal and they're willing to pay per month 1 lakh.
What do you do? What does your client do?
Travel agency business also.
Can be.
You also add the construction from that because last of this was already.
You cannot go on forever on that.
They have not given us a limited reply proposal. There was no written. It has been.
Give a copy of this to them.
But it has already been handed over. Oh,
They will hand it over in front of you. After order. Learned counsel for the award holder submits that the dues till date are to the tune of rupees 1, 12, 42, 494, whereas the award debtors have only given a proposal of payment of rupees 25 lakh, which is grossly insufficient. Which is the next para. Learned counsel for the award debtor submits that no response was given to the proposal of the award debtors till date. However, be that as it may, a copy of the breakup of the alleged dues relied on by the award holder is handed over here and now by the counsel for the award holder to her counterpart for the award debtors. Learned counsel for the award debtors shall take instructions accordingly as to whether the award debtors are agreeable to increase their offer further to arrive at a common point of consensus between the parties. As a last chance for the parties to resolve the matter out of court, the matter is adjourned till August 8, 2024. In the event no settlement is arrived at by that date, appropriate orders shall be passed by this. After supplying that to the copy of the breakup handed filed in court will be kept up.
Item number 16.
Same order. Okay. Up to 17. Up to 17. Should I make a composite order? Tell matters for a plural. The breakup of dues pertain to all the matters together.
There are 9 matters. I have 3 matters. This is one of those 9.
No. You have different breakups for different matters. Have you got copies of those breakups also?
This 9 breakups are for 9 different contract laws, and these 3 are one of those 9 contract laws.
No, একটা composite order. 15, 16, 17 and making a composite order.
Item number 18.
Yes.
Item number 26.
Go to the kid.
These are my lord the passing orders in all matters. this was the last direction of the lordship was to give another notice to the advocate on it. Now, what this is also doing for several times is using to take physicals for.
It doesn't practice here.
Yes, yes, yes. He has appeared before, my lord. My lord, I am filing two affidavits of service. One is, my lord, the last direction passed by your lordship, we have served it by speed post, the notice, and I have, my
We
lord,
have got two affidavits of service in all the matters.
my lord, the notice is with regard to all matters. We have not separate service affidavits for our other matters, but annexes are the same. My lord, this is an affidavit of service which
So what happened to this?
we have received by
Oh.
post. And this is an affidavit of service. my
What
lord.
was the page? Affidavits of assets have been filed.
Affidavits of assets have been filed.
Yes.
They have, my lord, on oath, and in the box they have, my lord, undertaken before this honorable court. It's a subject asset they will hand over. Subject assets are outside of West Bengal. We have given a place where it is, but not exact location. Thereafter, there are directions after this honorable court that we need to inform them name of the representative of our client to whom they will, my lord, hand over the assets. They are not, my lord, even taking
The
course of.
communication regarding the communication you have filed previously.
I look, I am filing a composite affidavit of asset.
This discloses the your
All the
communication.
orders, all the communications. Page 41, if your lordship says. The order of October.
So where have you communicated to your representatives then? That is also here. Please. Because the last order directed the name to be communicated. You have
Yes,
to
ma'am.
satisfy the court that you have communicated actually.
Hello, can you lordship this matter the next time? Explain that.
Affidavits of service filed today in connection with all the above matters be kept on record. First up, it is indicated that sufficient notice has been given to the award debtors to their advocates as well. First up, however, none appears to represent the award debtors when the matter is called on for when the matters are called on for hearing today. So next para. In order to satisfy the court that pursuant to the previous order of this court, the award holder has communicated the name of the award holder apostrophe representative to whom the asset was to be handed over, the matter is adjourned till August 8, 2024, when the award holders shall file further affidavits of service to satisfy the court that the name of its representative has already been communicated to the award debtors. Mr. Yes. Thank you.
Item number 27.
So, Thakkar, you are in 27?
Yes.
You are for the judge award debtor. So, Thakkar, you have got a copy of the affidavit.
Yes, I've got a copy.
So, what would you?
I want to examine the declaration of this affidavit. The earlier affidavit, it was affirmed by the director of the company. The directors are two brothers. One of the brothers is affirmed the affidavit. Now I find that some person claiming to be the general manager is affirmed. Lordship sees the new affidavit which is there, affidavit of affidavit dated 11th of July. This by Chandranath Day claims to be the general manager in paragraph 1. Whereas if your lordship sees the prior affidavit filed on 14th August 2019, it's by one Amit Saha. We have checked that there are two directors, Amit Saha and his brother, who are the Ashish Kumar Saha. Both brothers had filed affidavits. Directors had filed individual affidavits.
Again, affidavit ke pata? Yes, Amit Shah. Pardon?
The other day passed away, Ashish Shah passed away.
So, Amit Shah could have filed this. What was the direction? No, the award debtors were to file supplementary. Award debtors, the directors are not the award debtors, the company. Anyway, if you want to examine on this also, This is the affidavit there first. We can remove the situation.
I can examine.
So then, Mr. Amit Shah has to come. The
Most applicants I
on both. So I'll direct Amit Shah is our auditor.
He's the director.
I'll name him as a director of the company. A supplemented affidavit is filed today as per previous direction of court. Learned counsel for the award holder points out that the same has been affirmed by the general manager of the award debtor company and not any of the directors as was the previous affidavit of assets. Next para. Learned counsel for the award debtor submits that one of the directors, namely Ashish Shah, Ashish Kumar Shah, has since expired. Accordingly, the sole remaining director, namely Amit Shah, of the award debtor company, shall be personally present in court on August 8, 2024, for being examined by the award holder.
I missed the week.
At the 8th of August.
Item number 28. That's an and to limited.
And related to the award holder matter, we have received a letter from a judgment letter and they want to settle the matter. And Lord, should we explore that?
I must clarify, my lord. At the outset, my lord, I will kindly accept my unconditional apology. The last order, my lord, directed me to file affidavit of assets by today. I am tendering, my lord, my unconditional
apology is accepted, but what about the affidavit of assets?
My lord, the opponent, my lord, is extremely ill. He will require some time, my lord. It is on that anticipating, my lord,
Rare. Shall adjourn till change of determination. The how much time? Don't make a tall claim.
I am not, my lord.
You use your own discretion.
It's in Punjab, my lord. So my lord. Whatever, my lord.
Punjab has different timelines.
Absolutely not, my lord. I'm not suggesting that, my lord.
I can issue a precept to the Punjab for our judges who went there to them. So they can ascertain. No, I'll keep a day. I'll give you a week or a fortnight's time. Maximum fortnight.
Very good.
I'll give that time. Learned counsel for the award debtors seeks an extension of time to file affidavit of assets on the ground of illness of the award debtor. Next para. Accordingly, the time for filing affidavit of assets is extended for a fortnight from date. The matter a copy of the affidavit of assets shall be handed over in advance to the learned advocate for the award holder. So the matter shall next be listed on August 22, 2024. When the award debtor shall, who is the award debtor? Vis-a-vis the company? Director or what?
Well, Vidar Singh, my lord,
Vidar Singh is who?
He's my lord, one of the former directors of.
Because the award debtor is the company.
The award debtor is the company, my lord, no longer exists. It went to PIF.
Vidar Singh's name has been incorporated in the award debtors. Cannot be. Very well. When Mr. Didar Singh, one of the directors of the company who has been looking after the affairs of the present litigation, shall be personally present in court for being examined by the award holder. It is further recorded that a formal offer of settlement has been given by the award debtor to the award holder. Nothing in the above directions shall preclude the parties from settling the matter between themselves in the meantime, in which case the parties shall intimate the court as to such settlement, if arrived at in the meantime on the next return. Supplementary affidavit?
Lord, we had in a supplementary affidavit adjusting a bank guarantee which has been encashed.
Yes.
That you will serve it, a supplementary
You have filed that already.
long back.
A copy of the supplementary affidavit shall be served on the learned advocate. A copy of the supplementary affidavit used by the award debtor award holder shall be served on the learned advocate for the award debtor during the course of the day.
Six. That God makes me clear. I have five. Letter by which I have communicated the name of my yeah, I have
Already passed an order.
yes, I am not paying for 15 minutes.
So on the next day, rely on that.
Yes,
Rely on that. Just point out to me that this mistake.
yes.
My lord, item number 29, I appear for the, my lord,
Yes.
award holder.
Yes.
My lord, this is an application for execution, my lord.
Yes, let me hear
Am I
something.
audible, my lord?
Your senior is Mr. Banerjee? Achha.
No, no, this is my execution application.
No,
May I
somebody
just
is-
indicate, my lord, this is my execution.
No, let them hear them. Yes.
The CC has been filed at the attention of the award holder. I am the applicant over the third party application.
In short, what do you want to say?
This GA 2956 is supposed to be heard today, which is in regard to order 21 to 1901. It has been filed at my instance. This for that.
For the minor direction, us we have to receive our
Use the microphone so that it's in.
If minor receiver are directed to provide a report to
May I just cut short the matter, my lord?
Mr.
Since it
Banerjee,
is my execution.
order 21 rule 99 to 101 application has been filed. So let me decide that first.
My lord, that's exactly what I'm saying, my lord, to cut short the matter. My
Yes.
lord, this is my execution application which was filed in 2018 in respect of an award. The award debtors were represented and order was passed by Justice Shane, my lord, for sale of a land which belonged to the judgment debtors. Thereafter, my lord, the interveners herein, my lord, lordship will find, my lord, although there is no concept of intervention in an arbitration.
Mr. Banerjee, then decide that application first.
No, exactly. That's what I'm saying. That they have come and filed an application saying that their plot of land is.
Let them move it. Yes. Yes.
Very good.
Please move that application. Achha, what is your? This is regarding.
minor
This contains the bids or what? Let him. Let him.
that after this that
No, you are directed to proceed with the sale of the asset.
yes, my lord. Advertisement.
Give the mic to him. Give the mic to him. Take it away from yourself and give it to him. Use the microphone, Mr. Receiver.
First order.
You are Mr. I'm sorry. What is your full name? Mr. Mukherjee, please use the microphone. Yes. Working.
First order dated 25th July. The publication was made, but they are repeated. But after done on 12th September, your lordship passed the fresh directions for the application, but further by order dated 29/12/23, passed by the honorable division bench, then appeal directed the receiver not to open any envelope on fresh bids. After that, my lord.
Have you received fresh bids?
No, my lord, except one offer is coming recently from Mr. Sanjeev Bhowmik.
So you have enclosed that here.
No, my lord.
Why?
No, I am not enclosing because 2 or 3 queries is going on. And I told them to contact dinner company. All the get in details, my lord. And I told them for giving offer in
Very well. The after order record the receiver's report filed in a closed envelope today. Be kept on record. Full stop. However, no orders shall be passed. No orders need be passed there right now in view of pendency of J1 of such and such, which is an application filed by third parties. Your third party by third parties to the award, purportedly under Order 21, Rules 99 to 101 of the Code of Civil Procedure. Full stop. Next para. Such application is taken up for hearing first. Full stop. এখান থেকে কন্টিনিউ করবো GA is one of
The old number now is 74. J4. That is.
Acha list hai.
Yes.
So remove your application under order 21.
Order on three monthly part of credit.
Yes, it's what.
Receiver is, I will tell you on behalf, I want, the receiver is saying they received some bill subsequently. That the receiver is rather dependent to place that bill before the honorable court is.
Not right now. I'll not pass any order before getting their application. If they win this application, then everything goes. If they lose the application, then I'll pass on.
One more thing, it came up for consideration in course of hearing of this application. Justice Kapoor is the my lord, that whether this application for execution is maintainable or not. Because the state court has said it's an immovable property that is situated within outside the original honorable court. It's situated within CS Kashma. My lord, the decision in.
So make your arguments on that is also one of the your objection for that objection is also there. The first objection is then that territorial jurisdiction.
Jurisdiction.
And what about this order 2101?
It is my turn. In fact, what happens, Your Honor, my lord, sir, my lord, that this property, that is 57/1, that actually belongs to my client. They are not at all the owner, the JDRs. And
First, you have to satisfy me that order 21 rule 99 to 101 are applicable. 36 says yes, procedure regarding execution.
regarding execution.
How far? But then that will create an absurdity. Why I tell you? Because then a new hierarchy will be created, which is not envisaged in the 1996 Act. The 1996 Act does not provide any further appeal against Section 36 as such. Section 37 does not cover 36. So there is no further appeal. Now, Order 21 rule 99 to 101, if that is entertained, and whatever order is passed on that, that's a deemed decree. Against that, a first appeal and a second appeal may also lie because it's like a decree. So then we'll be opening up an avenue, a hierarchy of appeals, which is entirely beyond the contemplation of the 1996 Act itself. So whether we should read this Section 36, let us come to Section 36 once, to be restricted to enforcement and execution of the order, in the sense that suppose order 21 to 35 and the modes of enforcement are applicable, but the other modalities, the other provisions of the order 21, which are not directly relating to enforcement, but data enforcement, create third party rights, decide whether those can also be applied in 36. Satisfy me on that. As you have annexed your title deed to this application, that transfer occurred before the award. Before the award.
One minute.
The conveyance took place when?
Let me start from the beginning.
No. Tell me the date of the transfer and the date of the award only.
Sir, my lord, 6/2/2004 is a plea on the basis of which judgment debtor claimed that title. 6/2/2004.
And when was the award passed?
Award was passed on 16/11/2017. Much later.
Much later.
Much later.
That was 6/2/2004.
The deed on which they rely upon to prove their title.
Very good. Please proceed. Yes. Proceed with your argument.
What happened?
Yes.
We have already filed a suit challenging that deed, as because that lenders in that deed, they are not at all the owners in respect of this premises 57/1.
No, first to address the maintainability. On the maintainability, because I am of the prima facie opinion that order 21/101 cannot be opened up in the garb of section 36 in an arbitral proceeding. Now you have to satisfy me on the maintainability of your application, only then I can go into the merits.
Let us read section 36.
Hmm.
Provisions of this code relating to the execution of decrees, including provisions relating to payment under decree, shall, so far as they are applicable, is deemed to apply to the execution of orders including payment under an order.
Right.
My lord, we now refer to section 21. We are coming within the ambit of section 21, which relates to execution of
Order
Therefore,
21.
Order 21.
Yes.
Therefore, this section will apply here.
Right.
And 21, 99 to 101 permits are a third party
Automatically comes.
automatically comes with the party. And there are certain judgments also in that regard, which I'll refer you.
Cite the judgments first, because I'm hearing maintainability first. I'll hear you and him on maintainability, then I'll proceed further upon reciting.
Jurisdiction point is also very important. There is
And I've heard that also. You say that the property lies in Cosma, therefore outside original state. That you have already argued. What about these judgments?
a lot. And refer to 1995 volume 1 SCC 242. Case of Nuruddin versus K. L. Anand. Para 9. Para 9.
But this was given before the 96 Act.
After that, still holding. Still holding.
How is this relevant on the issue? We are hearing the maintainability of Order 99 to 101 in section 30.
I'll come.
Para 9.
Para 9. Adjudication before execution is an efficacious limit of health, fraud, operation, abuse. Object of laws to mete out justice, right to the right title interest of a party in the immovable property, the substantive right. But the right to an adjudication of the dispute that paper of behalf is a procedural right to which no one has a vested right. The faith of the people in the victory of law is the savior and succor for the sustenance of the rule of law. Any weakening like the judicial process would rip apart the edifice of justice and create a feeling of disillusion. It is the excellence then comes order.
What was held there, if anything was held at all, is that it has to be
It is the foundation for
Mr. Ali, let me finish. Let me finish. What has been held here is only that it is in aid of expeditious adjudication. It has to be expeditiously adjudicated. The rest is well known. So let us not waste time on this. Any other judgment?
Subsequent judgment, my lord, has been upheld. This has been upheld in Jimmy Dhanrajkir and another versus Shibu
What is the citation? What is the
223 2023 SCC online SC 643 para 19. Para 19.
643?
643.
Para 19
Para
beside
19.
that, yes.
Another, I'll refer, my lord.
Yes.
1998 volume 4.
First, let us finish this. Para 19, yes. What has been held there? Nuruddin has been referred to. Was bound to adjudicate. In civil suits, yes. All of these are civil suits. From civil suits.
The application of that.
We are not hearing this at all. In civil suits, Order 21 to 101 is definitely applicable.
Yeah,
Who disputes that?
also,
We are hearing at section 36 in arbitration. You show me that that is applicable to arbitration. Section 36 language is there. Apart from that, you are citing these judgments all on the scope of Order 21 to 101 in civil suits, which is not in dispute at all by anybody.
there's some more judgment.
Any on Arbitration Act, Section 36. Immediately show. Let us not waste time on these judgments.
Some short answer.
No.
2 or 3 days.
No. No further attendance, sir. No adjournment of this. You cannot waste time like this. Yes.
But 2023 city online city. Similarly,
Please repeat once.
2023 the CC online
Yes.
city 84.
84.
That's a more or less
Second. What does it say? Any paragraph?
there are two exactly similar.
Para 2 is the questions.
Questions,
The
let's
issues.
refer to the questions. The questions requiring determination by this court are as follows. What is the local standard of the objector and what is the remedy available to the objector who are not a party to the settlement that is other traffic? We are not a party to the driver and a subsequent memorandum of family that is the facts leading to the this was also an arbitration.
Right.
This was also still holds.
Let us come to the findings of
There are 11. There are 11. Eight.
para 10 is more appropriate.
Yes. That's what
Yes, sir. See para 10.
being made. Page 8 is page 8.
Is whatever para 10 is the relevant paragraph.
That's right.
Yes, I've seen it. That it is clear that by filing a petition under 2997, objector is not a party, but he can seek to obtain relief. Precisely your point. Any other judgment? Any other judgment on this point? No. This is
the latest.
what is the oldest? And I am being more strict because you are my classmate. I'm making it clear to the others. So that I know that. Definitely no bias or reverse bias. No bias or reverse bias. But I'll be equal as the others. No, but any other judgment, sir? This is better. Let us share the other side now.
And as of
Have you got an extra copy of this Justice Rai's judgment? Second.
I think one
এটা ওনাকে দিয়ে দাও। এটা look through this. Paragraph. So you say you have a prior title deed. If order 2096 and 101 is applicable,
prior. Deed is ineffective.
you have a prior deed prior to award.
Huh.
You have a much prior deed than the award.
Yes.
So you already had a right.
Already a suit pending for adjudication of that in respect of.
So when was the title suit filed?
Yes.
What is the year of the title suit?
Title suit has been filed. 2009/7/2007.
9/7/2007, and that was before the commencement of the arbitration also. Before the starting of the arbitration.
And this fact has been suppressed by them. They were there.
What is the stage of that suit? Any injunction in that suit or any?
Another suit.
That suit is still pending.
Still pending. Another suit has been filed by.
This award holder was a party there.
The party was in bid. The judgment came.
Obvious.
He purchased the property. He was the party. And in and there he filed a written statement and confirmed that we are its respect owners in respect different term, not corresponding to property appertaining to our term.
Yeah.
They say this that we are owners of the number 2122. They claim that 2122 has been numbered as premises number 57.
Well, let me get the maintainability issue first. If I hold in favor of maintainability, I'll direct affidavits to you guys so that I can decide. If I hold against you, then it goes.
And there is another suit where there is already an order of injunction.
That will be on the merits if I hold in your favor regarding it. Yes. Mr. Banerjee, only on maintainability, the Bernard Single High Court. The remedy is of a third party in an award also, arbitral award is also. But Total Rule 97, it has been stated. But rate with, after 101 of this.
My lord, on maintainability as on merits, I have no quarrels with my learned friend's property. He had filed a suit in 2007, did not get an injunction. I was not a party. Maybe the owners of this land was a party. And my lord, now during the proceedings in 2023 or 24, he has filed a suit and obtained an injunction. Let that injunction be there. There is no quarrel whatsoever with his property. I am not even interested in his property. Let me take my lord 10 minutes by the clock and finish off this matter pending from 2018. My lord kindly takes their petition, which is 29541. And lordship will kindly come to few paragraphs which are relevant. Kindly comes page 9, paragraph B, my lord. Page 9, paragraph B.
Yes.
This gives birth, my lord, the devolution, my lord, as to how the property has devolved in the, my lord, heirs. Now, kindly see, my lord, this property, my lord, that he is fighting about, not me. He is fighting about B, my lord, dag number 2123-2131. Lord, she will kindly mark that.
Yes.
I'll take exactly 10 minutes by the clock. I know my lord's clock, so I will take 10 minutes. 2123 and 2131. These are the two dark numbers that he is concerned about. Lordship gets it? Now, there is no dispute to this. Now, my lord, these two dark numbers, Lordship will kindly come to next page, which is, my lord, page 10 and subparagraph D. Lordship has got it, my lord?
Yes.
One of the dark numbers, my lord, is numbered as 56 and comes to paragraph E. Dark number 2123 is marked as 56, 57 and 57 by 1. Boshpuku Road, Kolkata 42. Lordship has got it. Page 10,
Yes.
my lord, subparagraph E.
E, all right.
Yes. Gifted their undivided 1/5 share, dark number 2123, premises number 56, 57, 57 by 1, Boshpuku Road, Kolkata 42. Lordship has got it, my lord.
Yes.
Now, my lord, kindly turns the page 11 towards the last, my lord, first paragraph, last 3 lines. In the said deed, it was specifically mentioned that the daughters of late Gyanoda Ghosh have no right and interest in 57, 57 by 1, Boshpuku Road, Kolkata 42. Lordship has got that, my lord?
Yes.
So, my lord, all that has been done is, my lord, now comes to page 12, paragraph G. This is very important, my lord. Page 12, paragraph G of his petition. That after becoming joint owners of plot number 57 by 1, Boshpuku Road, Kolkata 42, the confirming parties to the deed of conveyance, this is his deed, my lord, mutated their names in the assessment records of, kindly mark this, Kolkata Municipal Corporation, where the names of some of them, namely such and such, shown as owners of 57 by 1 and 57. Now, my lord, kindly sees the dag number 2123 and 2131. Lordship has got it, the same tag numbers. Now,
Yes.
my lord, that is numbered as 57 by 1. Now, my lord will kindly take there, my lord, RTI which they made, which they have enclosed at page 105. There is no dispute whatsoever. Kindly takes, my lord, page 105.
Yes, 105.
Now, my lord, they had made an application under RTI, that's the subject, my lord, with respect to, my lord, 57 by 1 and 50. Admittedly, 50 he is not concerned about, but he is the owner of 57 by 1, 56, 57. Now, my lord, kindly please, what is the answer? As reported by the department concerned, 57 by 1 Boshpukur Road has not been converted into premises number 50 Boshpukur Road. So, therefore, my lord, KMC is very clear that 50 and 57 by 1 is not the same. Then, my lord, as reported by the department concerned, it appears from the records premises number 57 by 1 Boshpukur Road and premises number 50 Boshpukur Road are individual premises. So they are separate premises. Cleared, my lord. Now, my lord, comes to the box. Recorded owner of premises Sri Lakshmi Narayan Ganesh Chandra and Sukumar Ghosh. Recorded owner of premises number 50. Now, what we are concerned about in our execution is premises number
57 by 1.
They are, I am not 57 by 1. I am not concerned. I am premises number 50. Now, my lord, why is this confusion? I will show to my lord. This is very, my lord, normal. This happens and lordship is aware of such matters. This has happened because my lord will kindly take, my lord, my opposition to their petition. Kindly comes to page 16, which is the deed of conveyance.
Right.
With regard to my property as the judgment debtors have it. The judgment debtor, my lord, lordship will find at page 17, my lord, the name is Messrs. Inbuild. My lord, that's the last paragraph at page 17. Lordship has got it. Messrs. Inbuild is the judgment debtor, my lord.
Parthojit
Now,
is
lord,
one of the partners and Parthojit is the owner of 50 also.
Yes. Now, my lord, kindly comes to page 21 of the conveyance deed.
Yes.
All that piece and parcel of Vastu homestead land, 6 katas and odd. Now, my lord, will towards the third line, lordship will find this is very important. Kindly mark it. Dark number is 2122. I am not in 2120 or 2131 as the dark numbers which he has. I am only concerned with 2122, which he is not the owner. That is his pleading also. Now, my lord, kindly sees what is the difficulty which had cropped up. 2122 district such and such Mauja, Taliganj, Jadavpur, now Kasba at present lying within the limits of Kolkata Municipal Corporation, ward number 67, district such and such, renumbered land at premises number such and such. Now, kindly, my lord, comes to the, my lord, page 33, which is the deed of mortgage. This is a registered deed of mortgage given to us. Kindly comes to page 40 and 41, which will clear up the entire, my lord, difficulty which has cropped in.
But that is premises of 57 by 1.
No, not at all, my lord. Kindly comes to page 40 at the last paragraph.
40 years.
The said mortgage property, all that piece and parcel of land measuring 6 katas, 5 chataks, dag number 2122. 2122 is not their land, my lord, admittedly. Then 41. Khotian number such and such, jail number such and such. This kindly sees, very important. Formally 57 by 1 Boshpukur Road under KIT scheme K3. When it was, my lord, under the KIT scheme, it was, my lord, the number was 57 by 1. The numbering takes place in that case. Presently known and numbered by municipal premises as 50 Kolkata 42. Therefore, my present KMC number is 50. His is 56, 57 and 57 by 1. So the lands are completely different. And in 41, lordship will find on the south by premises 57 by 1. Why should I be interested in his premises? Kindly takes page 41. His premises is in the south. My number was definitely 57 by 1, my lord, under the KIT scheme, my lord, plan numbers. It was the old number. He also may have had an old number. Now the renumbering is, my premises is 50 under the KMC 50 Boshpukur Road. His is 56, 57 and 57 by 1 Boshpukur Road. So there is no dispute. Let him have an injunction over 56.
But the KMC says that page 105 that it has not been 57 by 1 has not been converted to 50.
Correct. That's the, because he had asked a question whether 57 by 1 has been converted. Why will 57 by 1 be converted to 50, my lord? That's exactly why I showed that page. 57/1 is 57/1 under KMC records.
Page 41 of your opposition says 57/1, at present known as 50.
No, 57/1, my lord, under the KIT scheme. KIT scheme records were earlier, my lord, when Kolkata had KIT schemes, my lord, those lands were, my lord, lordship will know the refugee lands which were given, my lord, under the KIT scheme, their numberings were different. Now, my lord, the plots have been renumbered by the KMC. His number after, my lord, the renumbering has become 56, 57 and 57/1 under two.
Can I record your submission on the basis of your submissions? Can
Yes.
it be clearly recorded that you stake no claim to 57/1 Bospukur Road, Kolkata 7,42,000 as it presently stands?
My lord, lordship can record this. I claim nothing in respect of 56, 57, 57/1 under dark numbers, my lord. As I said, dark numbers, just give me one moment, my lord. I'll give the dark numbers. Dark numbers 2123 and 2131, which are the dark numbers of his land and which are his premises. I have only a claim in the execution with regard to dark number 2122, premises number 50 as numbered by KMC, which according to his plaint, according to his petition, he does not say he has any claim whatsoever. And that solves the problem. Let him enjoy the injunction over those properties, my lord.
Very good. Yes, what you said. These are
Admittedly, I am the owner of 2131.
admittedly by him. Admitted by him. Nobody else admits.
Corresponding to premises number 57/1. Now, my lord, I
No, I'll dispose of the application and as well as, I mean, your application and dispose of clearly saying that they don't claim any right at 56, 57 or 57/1 of that number 1.
have admitted our ownership.
No, admission, that is his problem. That I am not there, my lord. This is my
That cannot be done in this position.
lordship is not
The present application
here.
under Order 21, Rule 97 to 101 has been preferred by a third party to the arbitral award. To stop next para, although the issue of maintainability was sought to be taken up first by the court, comma, learned counsel for the respondent points out that the respondent within bracket award holder bracket closed does not stake any claim on the property of the third party stroke applicant in the application under Order 21, Rule 97 to 101, Civil Procedure Code. Question of next paragraph. It is pointed out from paragraph number 7 within bracket small b of the application that the claim of the third party applicant is restricted to tag numbers 2123 and 2131, comma, pertaining to present plot numbers 56, 57 and 57/1, comma, Bospukur Road, comma, Kolkata 7,42,000 in the records of the Kolkata Municipal Corporation. Which of next para, in the affidavit in opposition filed to such application, comma, it is pointed out that the property mortgaged to the award holder is entirely different from the property of the third party applicant, comma, being present municipal premises number 50, comma, Bospukur Road, comma, Kolkata 7,42,000 under municipal ward number 67 of the Kolkata Municipal Corporation, comma, which originally fell within within tag number 2122 and not 2123 and stroke or 2131 of Mauza Qasba. Full stop next para. As such, comma, the entire arguments in connection with the third party applicant can be resolved even without entering into the issue of maintainability. To next para, it is clearly and unambiguously admitted by the award holder that their claim is restricted to present municipal premises number 50, Bospukur Road, Kolkata 7,42,000 under municipal ward number 67 of the Kolkata Municipal Corporation, comma, which forms part of Dag number 2122 under Khotian number 472 in Mauja Kosba, full stop. On the other hand, comma, the property to which the third party applicant's stake claim is present plot numbers 56, 57 and 57 by 1, Bospukur Road, Kolkata 42 in the records of the Kolkata Municipal Corporation, which pertains to Dag number 2123 and 2131 of Moja Kosba. So next para, since the properties of the property of the third party applicant and the subject matter of the present award are entirely distinct and different, the implementation of the award does not and cannot in any way hamper the right title and interest of the third party applicants to their property in plot numbers 56, 57, and 57 by 1 Bospukur Road, Kolkata 42 within Mauza Dag numbers 2123 and 2131 of Mauza Kosba. Next para. Accordingly, GA4 of 2018 is disposed of in the light of the above observation, making it clear that the subject matter of the current execution proceeding has nothing to do with the separate and this property with third party. GA number 3 is GA number 3, the same year, 2018 of 2018 is accordingly disposed of as well.
My lord, now, my lord, my execution application, the receiver was asked not to proceed with the sale. Kindly direct, my lord, the receiver to make fresh advertisements in view of this order, my lord. That is, my lord, in EC 140, which is also appearing.
Yes, refer to order dated 25/7, where there was an order directing sale of premises number 57. That has to be reported. In view of this order, it has already been.
No, lordship will direct, my lord, sale of premises number 50. Advertisement for premises number 50.
If your lordship kindly.
No, what was directed? 57 by 1? They are staking claiming 50. Sale was directed regarding 57 by 1.
57 by 1.
Then that has to be recorded.
No, lordship will record, my lord, that lordship will kindly direct the receiver to sale premises number 50 only under the KMC. Clarify that and make an advertisement, my lord.
So it has to be, the process has to be started afresh, Mr. Banerjee.
My lord, that EC is appearing today, EC 140 of 2008.
The EC is appearing, but the process of sale has to start afresh.
Yes, we'll make a fresh my lord advertisement in view of my lord's clarification. Kindly directs that, my lord.
Order has to be recorded. 780. Has to be mentioned as well.
It is made clear that consequent to the above order, the previous directions to conduct sale in respect of premises number 57 by 1, Bospukur Road stands hereby recorded. Next para, the learned receiver shall, where is the receiver? The learned receiver shall steps to conduct sale in respect of premises number T, Bospukur Road, Kolkata 7,42,000. That page, yes, sorry, got it, yes. 50 Bospukur Road, Kolkata 742 under municipal ward number 67 of the Kolkata Municipal Corporation, pertaining, which forms a part of Dag number 2122 under Khatian number 472 in the Kosba, tail number 13, RS number 233 under police station Kosba in the district. Next para, then he has to be further remuneration also, Mr.
Yes, my lord, kindly will direct a date for advertisement and a returnable date because exactly those dates would be advertised in the newspapers.
One more thing.
No, let me finish this. Arakta line at Kudu. The advertisement in that regard shall be published by the learned receiver uh, within a fortnight.
Yes, my lord.
Within a fortnight from date, full stop. A report with regard to the outcome of such advertisement and the subsequent steps taken by the learned receiver or such sale shall be appended to the court by further report to be filed on the next returnable date. The matter shall next be listed on, I'll give you till 29th of August, more than 1 month. On August 2024 for passing further orders in that regard. So, sir, further remuneration of what was the previous remuneration? Now they have not given it. You have not got anything. So, Banerjee, he has to be paid his fees.
My lord, I am not aware, my lord, of this remuneration part. Whatever lordship pleases will kindly give me.
Acha,
1,500.
have you got a receipt? Acha, remuneration, further remuneration to the tune of rupees, to the tune of 2,500 gold mores shall be paid for the present to the learned receiver by the hour within fortnight from date.
Grateful, my lord, deeply obliged.
One more thing.
Yes, yes.
This renumbering part has not been shown. There is nothing on record to show this renumber. This has to be made. Again, some complications will arise.
The current numbers have taken because I cannot go into further. Then I'll be taking up the corporation.
My lord, before lordship rises, there is one more matter I'm told where, my lord, the person has been arrested and brought and they've mentioned it. I was
79.
Oh, 79 years.
Item number 79.
I'll fix another date then.
I make so for the
This is
yes, my
also-
lord, kindly records is undertaking, my lord.
Present on the next.
Kindly records is undertaking.
when can you appear next?
My lord, I was, as he has already started.
No, he has to be examined also.
Yes, my lord.
Warrant of arrest can stay, but when can he appear? He has to give an undertaking.
My lord,
I'll put it on 8th of August. Fine. Great.
affidavit of asset.
You have not filed it
He
there?
has to file his affidavit of assets, my lord.
So why don't you file it there?
That's why I was saying that I need to give me some time so I can hide the affidavit.
It's 1 week.
My lord, whatever my lord.
The
And the asset is still with them. The hypothetical asset is still with them.
the award data, I'll pass an order to that. The award data number 1, Kashim Khan, is present in court today. So, however, due to paucity of time, the matter cannot be taken up today. Full stop. The award data number 1 shall file his affidavit of assets. The award debtors shall file their affidavits of assets within a fortnight from date.
I'm only querying for the award data number 1.
The award data number 1 shall file his affidavit of assets within a fortnight from date with an advance copy to the learned advocate for the award holder. Full stop. Further, the award holder shall be present in court personally on August 8, 2024, when the matter shall next be taken up, for being examined, and shall furnish an undertaking to that effect during the course of the date. The award debtor shall not deal with and or encumber and or transfer the assets until further.
Grateful, my lord.
That's right. Suppose award minor and mentioned award holder to be present on
Award debtor. Award
My
debtor.
lord, only one prayer, my lord.
The warrant of arrest is stayed till August 16, 2024 or until further order, whichever is early. Yes, Mr.
My
Banerjee.
lord, only one prayer in the affidavit of assets. He must also, my lord, indicate the hypothecated asset location, my lord. Kindly directs that, my lord, because that is my asset he is holding on to, my lord.
It is further clarified that in the affidavit of assets, the current location of the said asset shall be mentioned by the award debtor.
Grateful, my lord. Deeply obliged. Deeply obliged.
PM on the next Thursday, Lordship, on the second of your Lordship,
Yes.
Thursday.
It will appear in the list. It will continue to appear. Continue to appear in the list. Whatever other matters are in the list, those will continue to appear in the list.
The problem is only this Lordship that the my your Lordship is it about 8 to 1 years and it is not well. But that reason only I am saying that if it is
So let me come back to then. I'll be coming back on August 8th. Then if I can't reach it, then we'll consider. judgment should have been.
For judgment. Also,
Accordingly, EP 37 of 2024 is allowed on contest, thereby extending the mandate of the arbitrator for a period of 6 months from date. Arbitral tribunal shall conclude the arbitration proceedings without granting any unnecessary adjournment to either of the parties and pass its award within the said extended period. In order to
item number.
I don't have a question. Then we have an application of the coordinate makes the certain amount has to be paid by the contributor. Whether in the last submission,
please repeat whatever you said.
so there was a direction where the line coordinate makes for making payment
Within order of
by the contributor with the security service provider. That is in my application.
Yes.
Whether there are two, another CP, whether another impression as indicated by the official liquidator that this CP has been disposed, transferred to before the landed company or tribunal. But the order that CP is different, which has been transferred. This CP is still pending. But this is a short application seeking a direction upon the landed contributory for making certain payments. This is directed by the earlier landed coordinate paying.
May I be permitted to make
Yes.
a submission?
Yes.
There are two CPs. Now, one is the CP 517, which is appearing with your lordship along with the CA application. And the order of the transfer in respect of CA, CP 120. Now, that has already been transferred, my lord. Now, they are the security guards. We have made this application because there was a peremptory order of making a payment, then only there will be a permanent stay in the stay of the winding up. Now, the total amount was 9 lakhs, out of which 4 lakhs 45 has been paid, and the remaining balance needs to be paid. So then the contributor, it has to come up because at the instance of the contributor, only this order of permanent stay was made by law. So the permanent.
There are party in the application.
I will serve on the
Yes,
court.
sir, we have served, madam.
This application also.
Yes, madam.
Actually, the same company. Only the CPs are different, maybe because of the two different petitioning creditors they have come up with.
We have to ensure that they get their money.
Yes, sir.
So, but this stay then there is no subsisting stay.
Subsisting stay subject to the payment of that. If your lordship
If
can
they have not
pay,
paid
so
it.
that the balance amount that needs to be paid, then only it will be permanently stayed. Otherwise, the winding up order still remains alive.
Clearly, you come to page 9 of the MI application, where there is a specific direction, if the payment has not been made, that's actually brought before the court order. Then since 2016, I am taking and making the official equivalent to contribute and not a single assistant has been received by the end of the.
No, already my lordship kindly comes to.
No, give me,
13,
Ms.
my
Asif, please give me.
Yes,
number.
sir.
So they informed to you.
Lordship kindly comes to page 30. Already the CA application is pending, that's CA number 20. I'm demonstrating from their own document.
To what
That
is it?
already this application has been filed because
This has been filed by you.
the CA, yes, my lord.
The C has been filed by you
Yes.
for that,
Filed by the
for payment of the amount by the
Yes.
contributor.
for the failure and the default payment security cost. It's their document they have annexed to their application, and I rely on that. But that has been filed. It's not.
That application is not before the court. You should have mentioned that on the last page. Have you got a copy of that application? But you had filed a report, you have said here.
Yes, application and report.
কোন report আছে এখানে?
Yes.
সেটা
That was in terms of a report. ma'am.
কি আলাদা করে?
The right of the order passed by the.
So I'll repeat the stay. I'll have to get it. I'll give them a further 1 month's time or a fortnight's time. You will communicate this further order to the contributory level. And when did I hold that this has to go to the other? Yes. Yes. I have to recall that order. Right. It is rightly pointed out by learned counsel for the applicant that this court had committed a bona fide error in the order dated July 11, 2024, when it was recorded that CA6 of 2024 is disposed of as not maintainable with liberty to the applicant to make an appropriate application before the NCLT with the self-same relief. First up, the premise of such order was that the connected CP had been already transferred to the NCLT, which is not the correct position as it appears from the record. Although a different CP within bracket company petition had previously been transferred to the NCLT, the CP in connection with which the present application was filed, that is CP 517 of 2013, was never so directed to be transferred to the NCLT. Hence, the order dated July 11, 2024, being based on an erroneous premise, is hereby recalled. CA6 of 2024 is taken up for hearing. It transpires from an order dated June 10, 2016, passed in connection with CA number 247 of 2016, that a coordinate bench had observed that an amount of rupees 9 lakh was to be paid to the applicant, which is the security agency engaged by the official liquidator, in 4 installments. The said amount was to be paid by the contributory. The learned advocate representing the contributory had submitted before the court on such occasion that the first of such installments would be paid by July 4, 2016, and the subsequent monthly installments would be paid on the 10th of each subsequent month. It was further recorded that in the event of any default, the security agency shall inform the official liquidator so that the latter can bring the matter to this court notice for appropriate orders. It transpires from the communication annexed at page 13 of the present application, dated July 25, 2018, that the official liquidator had actually filed a report and an application on the applicant having communicated to the official liquidator as to non-payment of the balance amount after payment of a part thereof to the tune of rupees 4,45,000. Next para. Since the contributory has failed to pay the balance amount of rupees 4,55,000 to the applicant security agency, in terms of the order dated June 10, 2016, the permanent stay of the winding up proceeding cannot be permitted to be perpetuated. In the said order, the learned single judge had categorically observed that subject to such payment within bracket of rupees 9 lakh bracket closed, and subject to observations made therein above, the winding up petition being CP 517 of 2013 was to remain permanently stayed. Next para. Hence, in view of such non-payment, CA6 of 2024 is disposed of with a direction on the contributory to pay up the balance amount due to the security agency applicant to the tune of rupees 4,45,000 within a fortnight from date. In the event, in default of such payment, the permanent stay granted in respect of CP 517 of 2013 shall stand automatically recalled stroke vacated without further reference to the court. Full stop. The applicant shall immediately communicate this order, communicate a server copy of this order to the contributory to ensure compliance. Full stop. The contributory, comma, upon such communication, comma, shall act on such server copy without insisting upon prior production of a certified copy for the purpose of compliance. Full stop. Liberty to the parties to mention CP 517 of 2013 for further orders in the event such payment is not made. 54, not 55.
4 lakhs.
4 lakh 45 has been given.
4 lakh 54 is given.
9 lakh.
But there is a 4 lakh.
Actually, 448 and 19.
445 was given. If 445 was given, then 4455 has to. 4 lakh 55, which I will add. If you want to take 1 lakh less, I can also take that.
Instead of taking responsibility matter,
This application is different. This no, I have said automatically without further reference.
and then unless it is payment will be taken, we have to come from further application.
See, I cannot hang them for non-payment. If they don't pay the state, it gets vacated. It was a rider. It was a condition of the stay being granted permanently. So if they don't pay, I cannot enforce this. This is not a degree of court. I can only vacate this stay which I have done already. Automatically, but you ensure that the copy is served. It will be on the server by today. Tonight. Yes.
Before taking up the next matter, my lord, next will be one with
Yes.
reference with regard to item number 120, 190, appearing under the miscellaneous. Sir, urgent matter, my lord, can it be taken up next Thursday?
Ms. Dante, I will not be there for the subsequent following 2 weeks.
Following 2 weeks, my lord.
Please mention it when I take up these matters on any day after they come back, and I'll put it up. Next.
Opening when I knew. Item 102.
Maya,
Please use the microphone. Yes.
Maya.
Yes.
535 of the Companies Act 1950
Right.
for disclaiming the property. As for the company went in not long back.
Yes.
We were not aware of the proceedings. This land the occupant of the land, which is the company under the Estate Acquisition Act.
Official liquidator should be present.
Yeah,
Anybody is applicant for that official.
Myself, assistant official.
So you are qualified to represent him. I'll hear it out. Yes. Yes. So you are authorized to represent him. Yes, I'll hear it. Yes.
not the company went into liquidation, the company which
You can take your seat, sir. I'll call upon you when required.
the
Yes.
land in which the factory was being run by
Yes.
Bengal Banking was vested with the state under the estate acquisition.
All right.
Around 0.315 acres vested.
Right.
Now terms of section 6(1)(g), if the land is not used for any factory or any other work, then it is supposed to be resumed
It was under the previous act.
under the
Yes.
now resumption proceedings commenced. We issued notices, nobody came. Nobody also informed us that the company has gone into liquidation. Then a survey was ordered in these resumption proceedings. The report I have annexed, the report says, for 30 years, there is nobody in occupation of the company. The kindly change page 21. Physical verification of stocks
Yes.
coming under 60. In accordance with the order, there was an order in the resumption proceedings. I, the undersigned, along with Sri Kalyan Nag, assisted by Varun Varai and Sri Kalipata Pal, of factory premises situated at such and such, nearly 1.5 miles away from Sirampur, to conduct an inquiry as to whether or not the factory
So he is writing to himself,
no, writing to
to the BLLR of Sirampur, and BLLR of Sirampur is the author.
revenue officer, Milord.
Revenue officer, comma BLLR. Revenue officer is the BLLR. So he is writing to himself.
Kindly takes the previous page, the covering letter. But this is by the subdivisional land reform officer to the manager Bengal. We give a notice that we will go. But your lordship is right. Revenue officer of the BNRO Milord has given this report.
Revenue officer is the BLLR. There is no revenue officer.
Produced to the district judge.
Any, what did it say here?
In the resumption proceeding. The resumption
Factory
proceeding.
building decrepit, so not used by this company. So it was vested. Thereafter, you allocated this to this company. The
For
company
usage, for use.
for usage, yes.
For using Milord as factory.
So what happened to this resumption?
Now, Milord, the resumption proceeding, Milord, what happened is pending, nobody has come and had paid leave to these documents, Milord, which are today, Milord,
Then what is the position of law, Ms. Banerjee? If you allocate it to the company,
as they are deemed lessees. Kindly take the notification, not page 24.
yes.
Terms and conditions for holding retained land by retainer, where an intermediate has been allowed to retain land in respective classification, and with or without any order under clause section 631 G. The Vested Acquisition Act or where such retainer has already transferred will come under that by an instrument mentioned. Such retainer or transferee as the case may be shall be deemed to such land or part thereof as lessee directly under the state law. Now, if he is the deemed company, the deemed lessee, then Milord, by operation of section 535 of the Companies Act, Milord, this land then becomes Milord onerous, and the institution Milord cannot use this land for any purpose. Then Milord, it has to be
Yes.
disclaimed.
A, under A.
There are Milord authorities, but in the statute,
Let me see what the authority of the official liquidity. Yes, what do you say, sir?
Lord, we will examine the issue in detail and accordingly next date of the
I'll keep it on 8th of August.
I'll file a supplement. The documents that are not.
But do that within 1 week and give a copy to him so that we can take instruction. Right. The counsel for the petitioner has made out a strong prima facie case for disclaimer, inasmuch as the property in question was allotted to the company in liquidation for a specific purpose, but having remained unused for over 30 years, resumption proceedings were initiated. To sub next para, learned counsel places reliance on the amended section, amended Rule 6, it's a Rule 6.
Rule 6.
Amended Rule 6, published with a notification number 3209 cap LP dated September 15, 2017, published in the official gazette of the same date, as per which such retained lands have the character of land leased out to the company to which it is transferred. So sub next para, as such, if the dual relationship between the applicant stroke state government, applicant stroke state and the company in liquidation is treated to be that of a lesser and lessee, comma, Section 535 within bracket 1 within bracket small a of the Companies Act 1956 is applicable, and such land of tenure becomes burdened with onerous covenants. So, sir, next para, learned counsel for the you are the deputy official liquidator. What is that official? The assistant official liquidator, comma, representing the official liquidator, comma, seeks some time to take appropriate instructions on the issue and to revert back to the court with such instructions. To serve on the prayer of learned counsel for the petitioner, comma, the petitioner is granted leave to use a supplemented affidavit within a week from date and give an advance copy of the same to the official liquidator, comma, incorporating certain further relevant pleadings and documents. To sub next para, the matter shall next be listed on August 8, 2024 for passing further orders. And it's here. What is it?
Status report. So your direction was to find a status report. But in this,
Then आगे order to prepare. Statistics. Paragraph 4 of
status.
statistical page.
In July 2024.
Yes, yes.
Sale of the assets of the property. Only
Yes.
the assets and documents sold. And out of the sale process, kindly see paragraph 5. History of the settlement of the claim, how the money was paid is total. That is. Kindly comes to state paragraph 8, page 5.
8, yes.
So that only one property, that is the required property, that is pending for sale. So that is the reason for which CA number 36 has been filed by the official in the official liquidator's application. One that the unsuccessful the check, demand draft, etc. And the seeking direction the fixed sale.
So that sale has not yet gone through.
Not yet gone.
So what is the stage of that sale? I mean,
fresh sale notice is required to be published by the official.
so the sale did not happen at all.
Sale did not happen at all. So that is the only property remaining. And the entire amount kindly see page 8 the prayer A, B, C, that was the prayer of the CA number 36. In that is in respect of the further process. And the amount which is lying with the office of the official liquidator, that is in reflected in para 9 page 7, only 2,18,991 is lying with the official liquidators and in respect of the company liquidations.
Which paragraph? The remaining. This is I'm looking into CA 37.
Yes, 37. I advise the official liquidator not to be CA numbers. Only CP numbers will be survived because If it is not being disposed of, then another application it comes, then only this report, maybe some conclusion, but last option also. Okay, kindly comes to page 7. That is the last page. Was 9 dollar present fund position. This is the only present fund position. And page 4, paragraph 5 dollar, kindly see the details amount which has already been disbursed among the security. So status report. I am submitting status reports. Paragraph 4 and 5. That is with regard to the sale of the assets and properties and the amount. Total amount 26 crores 791 was
There's the
disbursed.
that was dispersed.
That was disbursed.
Was paid.
Paragraph 8, page 5. That said, that is tendency of the property. Property. That is,
Right, present fund position is full account.
yes.
So what do they want now? What do you want now?
Can file an application in the direction for completion of the same. As on 1987, our claim was around 43 lakh. Right, and as on date it is around 27 crores. So our only application, our only prayer is for completion of the same procedure and for transferring the same. Because we are the only source to traders there.
They are the only.
It's only
The kindly takes summons of the CA number 36. You will also have copy of the summons.
36. Yes, sir. 36 এখানে রয়েছে। এইটা, yes. Sounds for direction.
Here, they kindly see. Also, court may kindly grant leave to the official required to return the demand drafts containing the amount earnest money. Property, so and so. And who have offered the same upon publication and on date or next day, the honorable court may kindly grant leave to the official.
Yes, that is the only remedy now available to the what can what else can.
Yes.
So how soon can I mean what time should I give it for completion of the sale? Fresh be done.
Saying 1 month.
Yes, 4 weeks definitely. I'll get to that. So should I keep the applications pending? I'm allowing your prayer actually.
Yes.
Sure, I'll learn this. Status, definitely.
I'm handing over.
Yes. The status report filed in court be kept on record. Question. The learned official learned counsel for the official liquidator also hands over a copy of the same to the learned advocate for the applicant. Question next para. Upon going through the status report, it transpires that the official liquidator has already settled the amount, and the entire amount of sale proceeds from previous sales have been distributed among secured creditors. The present fund position of the company in liquidation is rupees 2,18,991. Learned counsel for the official liquidator submits that only one immovable property, being a flat and measuring 875 square feet situated at Worli, WORLI, Mumbai, is left to be sold. Next para. Since the previous attempt to sell the same did not go through, the official liquidator seeks further time to initiates the process of sale of such asset in order to meet the demand of the applicant from the said sale proceeds. Next para. Accordingly, CA 36. There are two applications, 36 and 37.
37 is our application.
So both your application is 36.
Yeah, my
So I'll dispose of both. Then
37 can be kept pending because unless the sale is completed, till then it can be kept pending.
very well. Accordingly, CA 36 of 2023 is disposed of by directing the official liquidator to take immediate steps and complete the process of sale of the remaining asset, that is the immovable property, being a flat at measuring 875 square feet at Worli, Mumbai, at the earliest, within
By making paper publication, I will kind
by making paper publication.
she's kind of grant also publication, name of the publication, either statesman or.
Why should I name a particular paper? Paper publication in it will be only one newspaper or two newspapers. In 3 newspapers having moderate circulation in the vicinity of the asset, one of which shall be in English, the other in Hindi. Third should be in the local vernacular. And the third in the local vernacular prevalent in the area. Full stop, such process shall be concluded by August 20, 2024. Full stop. The
Kindly speaks the sale.
no sale date will fix. I'll give you that liberty. Otherwise, there may be certain exigencies coming up. Again, COVID happens, and you fix that. I've just given the mode, and I keep that flexible for you. But I'll put the outer limit at August 20.
But liberty may be given to the official limited to mention this matter to the lordship for fixing a date of sale. That would be survived. At that point of time, your lordship.
Why is it that necessary also?
Because your sale is required to be confirmed by your lordship.
Yes, the sale is required to be confirmed, but the sale date will not be fixed with the consider.
On that day, one of the your offers, they will present before the court.
Right.
But after completion of this proceedings for liberty may be granted to the official limited to mention before your lordship for fixing.
Mr. Bell, liberty is granted to the official liquidator to mention the matter for inclusion in the list before this court for the purpose of confirmation of the sale. To stop, then should I make it returnable on a particular date? Then it has to be before August 20th. The matter shall next be listed on August 8, 2024 for passing further orders. Further orders, when the matter shall be listed, because I disposed of 36, when CA 37 of 2023 shall be listed before this court.
Instead of 8,
this is taken up only on Thursdays, and there is no other Thursday before 20th. Because I will not be there for the next week.
your lordship already fixed the matter on 8 for mention. So, kindly that may be kindly put this on 28th.
20th itself. Then the same process can be concluded within that period. Is the outer limit.
Publication, inspection, and
ঠিক আছে outer limit যেটা বললাম না যেটা যেখানে August 20th বলেছি August 20 সেখানে August 31, 2024 the matter shall next be listed on 22nd August. On August 22, 2024 for passing further orders.
unsuccessful bidders already.
The EMD of the unsuccessful bidders of the last attempt to sale be returned to the unsuccessful bidders by the official liquidator in the meantime. Thanks.
connected.
103 and 104. Yes. Yes.
Whether that this claim it will not be 107 can be taken up first. That is C44. Because CO44 is not said. There has been a property at Mysore, which is possession.
Right.
Now there are security expenses your lordship that is getting incurred day by day. So my humble prayer at the date of this application is possibly with the secure creditors. They have also filed some of the application for disbursement of and C43 is our application for disbursement of it. So my humble prayer is that if the secure creditors can share their liabilities towards the security expenses. Because this property is a litigated property, your lordship. The appeal is also pending, your lordship. So by dint of which we cannot go for the sale proceedings. But since the security expenses are incurring, your lordship, the interest of your creditors can
So then that has to be adjusted subject to hearing.
that has to be adjusted.
Adjusted from the proceeds due to them.
Yes, CA 40.
But we have.
I'll come to you. Without hearing you, I cannot pass.
Lordship, CA 42 is the application of the State Bank of India
For
for disbursement of the bill.
obviously yes.
CA 43 is our application for disbursement of the bill. Lordship, we have given the exact calculation on what basis.
Mr. Prasad is appealing for whom?
For the fund organization.
Yes, we have already lost the claim.
For
Provident for
Disbursement.
department.
For
We have
disbursement.
lost the claim, Lord.
So this is 43 and 44 is an separate
so
application.
43 is for disbursement to State Bank.
To all the
To all
creditors.
the
To all the
right,
creditors.
right,
That is for this application has come based on official.
right. And 47 is for this.
44, CA 44 is again application which has been submitted, okay, has been taken up by the official. Seeking for the expenses that can be shared by the creditors.
So what is the mode suggested by you that share of dividends it will be adjusted from that.
From that.
But for that you have to come up with a bill. I mean, actually, what is the expense?
Next, we have annexed with the application HCA 44. We have annexure C. This is the annexure C
Alright.
the bills of the security.
So this is the expenses still today.
No, this application your lordship has been taken up in the year 2023.
Oh.
So this is 2024.
So the current amount will be much more.
This is the current amount will be much more.
So I may, on principle, if you decide on this, then I can direct you to produce a current bill. Yes, what do you say to this? This is reasonable.
I'm saying about I think about the rupees, 5 lakhs of rupees not have been sent from by the Lord Bank to them. That money must be tied with them. The government we are getting some.
High blank has been sent by the bank.
By the bank because the matter was yes, we call it tracker. One of the property was sold by the at the place of the bank tracker. I do not
No,
know.
they will have to pay you from whatever proceeds they are with them, whatever is the funds of the company's liquidation. From that, adding whatever amount has come to that, they will have to give an account of that. But on this adjustment of security, you are agreeable. What about you?
We are the
But the security,
the bank and they are the
yes, bank. What is
On that is kept pending. There,
what is kept pending? But it cannot go from the public coffers. Also. Official liquidity, if the official liquidity is to pay, that has to be from the public pocket. Why? Because they are protecting your property for you only. Yes. No, the security amount they have already disclosed. On principle, you have to decide first that whether this payment can be adjusted from your due. Satisfy me why it can't. I'll ask you to furnish a fresh current up-to-date account. Actually, what is the amount? You will do that on 8th of August with circulation of prior copies to them and pass orders on this. But I'll hold on principle that you are intended to this.
Lordship, a meeting was convened by the official calling for all the creditors of the LICI has not agreed to function and State Bank there is no indication of any.
CA 42 of 2023 has been filed by the State Bank of India, one of the creditors, for dispersal of its share of dividends. Pushta CA 43 of 2023 is by the official liquidator seeking directions for dispersal of the dues of all the secured creditors. Pushta, on the other hand, CA 44 of 2023 has also been filed by the official liquidator, seeking adjustment of the dues and expenses spent by the official liquidator for the purpose of security of the assets of the company in liquidation. First up, it is submitted by the counsel for the official liquidator that unless such amounts are adjusted, comma, which have been spent for upkeep of the assets themselves, comma, the funds ought not to be directed to be disbursed to the creditors. First up, upon hearing learned counsel for the parties, comma, it appears to the court a justified claim by the official liquidator that the amount spent on security of the assets, comma, the assets, comma, from which the dues of the secured creditors will be met, MET, comma, ought to be shared by the secured creditors themselves. Accordingly, the official liquidator shall furnish by way of a supplementary affidavit a further bill, comma, indicating the up-to-date expenses as indicating the up-to-date expenses
And the present fund position.
for security services, as well as disclosing the current fund position of the company in liquidation. Such supplementary affidavit shall be filed on the next return date, that is on August 8, 2024, when the matter shall next be listed, comma, with an advance copy to the learned advocates for the applicants in the for the learned advocates for the other parties. I'll pass for the order for that. I held that on principle you can adjust that amount, but you also disclose the fund position. He's right on that. Mr. Prasad is right.
8th of August.
8th of August, yes. I take up these matters only on Thursdays. So.
And an 8. I have again that. My application.
Right.
On the last occasion, your worship has directed us to serve a copy of this to WPITC. Actually, I'm for the I've complied with it. Serve a copy. It's a short point, your lordship. Our claim has been accepted by the official security creditors. 23 crores has been accepted. Meanwhile, the PIDC and customs, they came forth and they said we also have a claim. This was done way back in 2008-9, part of the status report of the official. But they have yet to file their claim in any manner. Time and again, repeatedly, letters have been issued to them to file their claim. They haven't filed a single claim so far. The official liquidator has been sitting on an amount of almost about 7 crores 91 lakhs on sale of Lot 1 assets since 2008-9. And we are the only secured creditors. So far as customs are concerned, your option will be very categorically stated. If you kindly look at the status report filed by the official liquidator at page 8, your option.
Status report.
An order passed by Honorable Justice Sanjeev Banerjee on the 3rd of February 2012.
I'm sorry, please give me a page number.
Page number 8 of the status.
Yes.
Since the custom authorities have shown no interest in the matter, the OL will write a letter to the custom authorities for such authorities to take the boiler that remains charged for payment of the sum due to the custom authorities. After writing such letter, appending a copy of this order, the official liquidator need not take any further steps in respect of the boiler or the glass molding machine taking them, since it will be open to the custom authority to deal with the same. And it is disposed. So, as far as customs are concerned, they are well protected because there are certain boilers and all which are lying under the custody of the customs. So, they have no claim in any manner except for the charge over the assets. As far as WPIDC is concerned, your lordship, time and again, letters have gone. They have not done anything. They have not filed their claim. And I personally feel, to be very candid, your lordship, what claims they can have is maximum maybe the rent. They cannot be secured creditors under any circumstances. They are the only secured creditors in this.
So, is the WPIDC represented here? Customs, you get the boiler.
No, my lord.
This manager is giving you the boiler and the glass.
My lord,
You live in glass houses then.
whether
The glass molding machines.
whether that has been sold or not, or whether any amount has been received by me, that has to be ascertained by the year of 2000.
Minus the boiler, the rest of the amount they are
We
shared.
have handed for the empty Godawan. Whether this the machine was there or not, that
Do you also have any application here? Your
my-
claim has already been restricted in 2012 by Justice Banerjee with the boiler and the glass molding machines at
but that I don't find by lord. That has already been sold. Then I have a claim.
No, but that is under the custody of the customs, your lordship.
No,
They
no,
have
Let
the-
us hear the official liquidator on that. Yes, what do you say is Vitoni?
No, Lordship, they have not informed us whether they have sold their assets or not. That
Who have
boiler
not sold?
and
It's not with you.
customs, they have not informed us, Lordship.
No, the boiler, let me be clear on this. In whose custody is the boiler now? Who is in charge of the boiler?
Customs.
It's with the customs.
Yes, Lordship, because there is an, Lordship, kindly come with the status report, Lordship.
Yes.
They have filed a claim before the official liquidation. Thereafter, they did not, we could not adjudicate their claim since they have not filed the proper documents.
Hmm.
So we have asked several times. In spite of that, there's customs and WBIDC did not appear before the official.
Right.
We have only adjudicated the claim of the petitioner. That states as a
Right. Right.
that's it.
So you have settled their claim.
Yes, Lordship. That
What
is said.
prevented you from disbursing till now?
No, on last occasion they had appeared and they said we have a claim, but Lordship, we could not adjudicate their claim because they have.
But the
not
claim has been
fully-
settled by Justice Banerjee. It remains confined to the boiler and
If
the
your
gas.
Lordship, then WBIDC is there.
They have not come. It's their
And
headache.
For
They
your
don't come.
Lordship.
They have never
And-
come. You have served this affidavit of service is there.
So,
WBIDC has to.
But what happened, Lordship, in this matter, that's customs claims. We have come to know that 11 crores, 99 lakhs or something, and WBIDC's claim is 174 crores.
But the WBIDC has not yet made any claim with you.
They have filed, but they did not come.
They have filed a claim.
Yes, Lordship, they have filed a claim.
Is it reflected in your status report?
Yes, they have filed a claim, but we could not adjudicate their claim since they have not filed the proper documents with that claim.
Where have you mentioned about that? Please show me that from your report.
So, Lordship, kindly comment, please, for Lordship,
Yes.
that the Lordship,
Yes.
that the official liquidator has received money from space asset stabilization fund credit for the records such and such by way of affidavit, but no claim was received from WPITC and the customs office, but further in compliance of the order of the Honorable 13 December 2011, the official dated to WPITC and the Assistant Commissioner of Customs requesting to be present in the meeting to be held on 2011 along with all relevant documents in respect of their claims against the company. The same means the customs office that their development has confirmed the demand dues against the company for an amount of rupees 11 crores 99 lakhs. But it did not file affidavit as required under Rule 151 of the Companies Code Rules 1959. On the other hand, WPITC also did not file any affidavit of claim nor respond to the letter dated 13 December 2011 by the official. Yes, Lordship.
So they have not filed their claim. So then,
Sorry, they have not
and
filed.
they have not filed their claim at all, and customs has not filed this affidavit.
Yes.
Until the date of passing of order by Justice Banerjee, they had not apparently.
And we come to the application case, but thereafter the
How do you get over Justice Banerjee's order?
thereafter the order has been given.
Where is that? Page,
Page 41 of the application, main application.
main applications.
That is
Page 40. acha, correct. Yes.
CA number 9 of 2000.
Page 41. Yes. Justice Kapoor's order.
Yes.
Yes. Please that please.
That in view of the accommodation for on behalf of the parent, the third parent. In view of the accommodation on behalf of the customer, this matter appear on the mutual liberty is granted to the customer because their claims with the official liquidity.
This was the coordinate bench. It was not placed before the coordinate bench that you had already made your claim. But it's a question of further claims being made by you. This cannot be there in the teeth of just Banerjee.
But that
This has to be read in context of this. No liberty was given to you. Liberty was given in the sense that you had not.
my lord, your lordship will kindly come to place now the
This
status.
was not an adjudication on any issue. Reopening the.
My lord, your lordship will kindly come to place the 25 of the status report filed by the official liquidator.
Yes, please. 25.
My lord, that
Yes.
is on 2012. With regard to the importation of second-hand machine of ancillary equipment and marketing machine, second-hand machine imported by Procedural class during 96, a discussion was held in the chamber of the official liquidator on 21st December 2011 at Suggestion Center. During the run of the meeting, the customs department has stated that a demand notice was issued to the company liquidation as regards machinery imported by the company number claim was submitted to the official at that time. Jealous copy of the demand notice was handed over to the registrar, was also submitted for a confirmed demand of this such and such. Now the possession of the empty godown number 1 has been already been handed over to Mr. Tolara, and the case number 60 has been discovered. There is a need to get back the duty of rupees such and such with interest.
Who is Mr. Tolara?
Who is Tolara? He is the erstwhile of the that
Company. Of company.
company. My demand is 11 crores.
But you have not filed an affidavit, anything in support of this.
No, I have filed it. Subsequently, we have filed mine.
Where is that affidavit?
My lord, has not been my lord. Then my lord, I have to produce the same documents before the court. But I will find the affidavit. By disclosure, my lord, your lordship will kindly see my lord the main application.
They have written to you on 12th of October 2023, page 26 of the status report. They have specifically written to you.
Yes. That's why I am saying, my lord, whether after that we have issued any legal report, my lord, that I will clarify by filing a affidavit. Kindly allow my 7 days time, I will file it.
I mean, this make one submission. Lordship, so far as customs are concerned, we are restricted only to these boilers which are lying with them under their custody. They cannot raise their claim over any other properties of the company under liquidation. Because they are only secured only to that extent, your lordship. That the materials which have been imported in
So they refer to a go down number 1.
this is lordship, this is not their go down. I don't think this is their go down. They are trading their, so far as my knowledge goes, subject to correction, your lordship. They are only demanding duty within.
And that go down handing over was in respect of something else, sir. Page 25 of the report. Now that the possession of empty go down has already been handed over and case such and such has been dispensed with, there is a need to get back to the duty of rupees such and such. So that go down is not a part of your.
Not a part of it. Go down is not my part.
Your
My part is the duty, only duty.
No,
That has to
your
be
learned friend is
secured
right on this because your claim is restricted to that boiler, whatever is secured with you. And Justice Banerjee closed that chapter.
my commission cannot see.
Do whatever you can with that boiler.
But if the boiler is not with them, then what can
Boiler is with you.
It is boiler, but when I have handed over the empty go down, that
If you
is
could
the-
not ascertain whether the boiler is still with you, and if you could
That's
not
why-
find time to file an affidavit since 2008, 2009, then I'll not open that chapter for you.
No, I am
Just-
not going to that, man. I want to submit.
You should have filed an affidavit. Repeatedly, you were asked by the official liquidator. That is evident from the
But
status.
that extent, I have lost my claim, man.
You have lodged a claim long back, sir.
Yes.
This is the fresh claim you are lodging.
No,
But Justice
today I am
Kapoor's
not-
order did not. No, see, your claim was initially filed, I'm telling you. Much back, much back. When did you make the first claim? Just show me that from the status. The customs.
So part of the report at page 4,
Page 4.
that customs authority indicated that development has confirmed that department issue has confirmed the demand used against the company liquidation for the amount of 11.99 Act, but did not file affidavit as required under section 151 of the company's rules. 1991.
It must have been prior to 2011 because 2011 pursuant to that order issued the
Yes.
official liquidity issue. Yes, you have made your claim before 2011 and you were asked to file affidavits. You did not do that.
No, no, but after the order was the
Justice Ravi Kapoor did not open up a new channel for you.
no, no, no.
Your
He
claim had already been made back 2011, sir.
At that point of time, we have not filed the claim. Thereafter, the liberty was given to us to file.
Unless you filed a claim, where was the question of filing affidavits as required under Rule 151?
On that basis, my lord, according to yes, sir, my lord, at that point of time, we have not lost the claim. Thereafter, subsequently, as the liberty has given to us, we have lost the claim. Therefore, the official liquidator has directed us, what is the present status, you inform us. That is the last later, my lord. Can we see the report, my lord? They have asked what are the documents and what the development is still.
What is the full, have you annexed the full copy of the order dated 3rd of February 2012? Justice Banerjee's order? Is that a part of this? Either the application or the.
But it's at page 23.
I have
23, right? So this is the entire order. No interest means what happened before that? Were there in prior orders of Justice Banerjee? Must have been. It's not there. Justice Chakraborty's order was after it. I mean, this is abrupt rather. I don't get what happened before this.
In fact, your lordship, if you look at page 22 also, the official liquidator has written a letter to the customs that enclosing this order and stating that in terms of the said order, you are requested to take the boiler that remains charged for payment of the dues of the customer. So time and again, opportunities have been given to the custom authority to sell the goods and recover whatever they want. I want to submit that these where the custody of the customs or not, and when we have given the empty godown, at that point of time, the books were there or not, and whether we have sold this book.
What are the funds with the company?
7 crores, lordship, I have stated in my status report last page, 7 crores 91 lakhs 40,000.
Have you stated anything regarding, the fund position? Have you sold any of the assets?
Yes, lordship.
Must have sold.
Yes.
So is that list given somewhere here? Or what
It's at
assets you have
page 3,
sold?
page 3.
That does not include the boiler, must be.
No, it doesn't include.
No.
Then whoever is in custody of the boiler, that remains charged with you. But since they have not sold that boiler and the proceeds which is now there, the boiler does not form a part of it. Therefore, that can be disbursed from that. Their share can be disbursed. That cannot be ascertained.
That has to be ascertained.
We do not ascertain for 12 years.
Whether we have bought this boiler or the books or not.
No further.
Kindly give me 7 days time. If I bought this boiler, then I can
For what?
whether I have sold this boiler or not, and whether I have gathered the amount or not.
Even if you have not sold the boiler, either you have sold the boiler or not sold the boiler, your claim lies restricted to that boiler. They have a fund. They have sold certain properties to get that fund. That property list does not disclose the boiler. Therefore, the boiler still remains either with you or with them. Whoever it remains with, the boiler, if the boiler was also a part of the sold assets, then you might have had a claim there. But your right is restricted to the boiler. Whoever the boiler is lying with, that is irrelevant for this purpose.
When I have taken possession at that moment of time, whether the boiler was there or not, that I want to.
You are in the best position to say right now.
That's why I am playing on a kind
What is your instruction on that?
My instruction is it is a matter of 2012. They are instructing your thoughts and kindly allow 7
I'll record that you asked for time.
kindly allow.
No question. Not further. The applicant in your filed a CA, separate CA. Yes, the applicant in CA 9 of 2024 claims that it is the secured creditor of the company in liquidation. The process has been ongoing since 2008-2009. On previous occasions, the official liquidator had written to the 2 other claimants, purported claimants, comma, the WBIDC and the customs, comma, for making their claims and or for filing their affidavits of proof, comma, but in vain. Full stop. Next para. Learned counsel places reliance on an order dated February 3, 2012, where a coordinate bench had observed that since the custom authorities have shown no interest in the matter, comma, the official liquidator will write a letter to the customs authorities for such authorities to take the boiler that remains charged for payment of sums due to the customs authorities, who stop after writing such letter, appending a copy of the said order thereto, comma, the official liquidator need not take any further steps in respect of the boiler or the glass molding MOLDIN machines relating thereto, since it will be open to the customs authorities to deal with the same. Official liquidator or customs authorities into capsule. Full stop. Next paragraph. It is submitted that even thereafter, comma, the customs authorities having failed to furnish such affidavit, despite being intimated of the order by the official liquidator, comma, the claim of the present applicant in its share of the dividends cannot be uh, postponed further. Full stop. Next para. Learned counsel for the official liquidator places reliance on the status report filed by her client. Full stop. Next para. Learned counsel for the customs authorities specifically argues that it is not clear to the customs authorities as to whether the boiler or the glass molding machines are lying with the customs and or have been sold and the proceeds appropriated in lieu of the claim of the customs. Full stop. Next para.
Find our claim. I have 96 status report case 26.
You are yet to file your claim.
No, we have.
Yes. So it is further submitted that the customs authorities have already filed their claim, which is annexed to the status report at page 26 thereof. Full stop. Next para. A week apostrophe adjournment is sought on behalf of the customs authorities for the said authority to furnish before this court an affidavit disclosing the present status of the boiler and the glass molding machines and as to whether those have been sold for appropriation for the purpose of meeting the claims of the customs. So, next para. Upon hearing learned counsel for the parties, comma, a common refrain underlying the entire matter seems to be the gross inaction on the part of the WBIDC and the customs authority. Full stop. Next para. It is evident from the status report of the official liquidator that as long back as on January 29, 2009, comma, leave was granted to the secured creditors of the company in liquidation to lodge their claims before the official liquidator. Full stop. Accordingly, publications were also made. Full stop. Next para. However, comma, there was no claim at all at any point of time by the WBIDC. Full stop. Next para. Although initially there were no claims from the customs authorities as well, comma, subsequently in compliance of an order dated December 13, 2011 of this court, comma, the official liquidator had issued a letter to the WBIDC and the Assistant Commissioner of Customs requesting to be present in a meeting to be held on December 21, 2011, along with all relevant documents in respect of their claims. First, in the said meeting, comma, the customs authority had intimated that their development had confirmed the demand dues against the company in liquidation for an amount of rupees 11, 99, 55, 883.30p, but did not file affidavit as required under Rule 151 of the companies within bracket court within bracket close rules, 1959. On the other hand, the WBIDC did not file any affidavit of claim nor responded to the letter dated December 13, 2011. Next para. As such, insofar as the WBIDC is concerned, comma, it is a closed chapter for them, comma, since despite repeated communications by the official liquidator, comma, not even any affidavit of claim has been filed by them, comma, let alone any affidavit of proof being furnished to substantiate such claim. Full stop. Next paragraph. As far as the customs is concerned, comma, in a meeting held on December 21, 2011, comma, that is 13 years before, comma, the customs authorities were intimated the requirement to file an affidavit of proof, comma, which they have not done till date. Next para.
But that has been done.
When?
But 2023, pursuant to the direction of the order, just
Very good. That has not been done.
kindly come to page 26 of the status report. Official report.
When did you file that affidavit?
But this is with reference to letter dated 26.
Not done before October 12, 2023. Good, sir. Next para.
Now, at least
Insofar as the claim of the customs authority is concerned, comma, however, comma, in the order dated February 3, 2012, comma, a coordinated bench of this court had conclusively held that the claim of the customs authorities were restricted to the boiler that was charged for payment of sums due to the customs authorities. Next para, at best, comma, in terms of the said order, comma, the customs authorities might have further rights on the glass molding machines relating to such boiler. Next para, in the absence of any challenge to such order, comma, the said order has attained finality. In any event, comma, even till date, comma, the customs authorities have not produced anything to indicate that the charge for the claim of the customs went beyond the said boiler and or the glass molding machines relating thereto. Next para. Hence, comma, the question as to whether the boiler and the glass molding machines are lying with the customs authorities or have been sold in the meantime is utterly irrelevant for the purpose of the present claim of the applicant. Next para. Irrespective of the fate of the boiler and the glass molding machines, comma, which were the entire extent of the charged property for the claim of the customs, comma, it is evident from the status report filed by the official liquidator that such boiler or glass machines were not a part of the assets which were sold to arrive at the fund which is now lying in the coffers of the company in liquidation. Next para. Thus, comma, there cannot be any. Thus, comma, the claim of the customs, comma, which is restricted to the charged boiler and glass molding machines, comma, cannot in any manner come in the way of the share of dividends of the present applicant being disbursed in favor of the applicant out of the present fund position of the company in liquidation. Full stop. Next para. Insofar as the customs are concerned, comma, nothing in this order shall prevent the state authorities from furnishing their affidavit and or other documents in order to satisfy the official liquidator as to the outcome, as to the fate of the boiler and the glass molding machines to exact their extent of the claim. So, next para. In view of the above observations, comma, CA 9 of 2024 is allowed, comma, thereby directing the official liquidator to disburse their claim has been settled. The settled claim amount of the applicant in favor of the applicant at the earliest, comma, positively within 4 weeks from date. Full stop. It is made clear that nothing in this order shall prejudice any rights which the custom authority or the WBITC might otherwise have in law uh, in respect of the company in liquidation.
If we hold only land building sheds from.
Boiler is not included, that is only what is there.
Yes. That we have already published.
You pay part of the court fees there. It's their application. You have not filed, you have not taken any interest. Only after you people were engaged, where we have started taking interest. Not done. Thank you.
109, 110. Or the application. Yes. The affidavit was filed. There's a property which is not belong to the company.
Right.
My mother was the owner. The mother
This is a disclaimer.
Yes, disclaimer. Mother was the owner. She died. On the natural laws of succession, the husband and the three daughters.
So what is the claim of the company?
Company was a tenant in respect of the property in question. Affidavit in opposition filed. Where there is an explicit admission the property belonging to the mother in question, and we are the legal heirs.
So opposite,
That they say now they have lost.
opposition.
So they wanted to file again. I can give my copy and use the
No,
legal.
have you filed the opposition or given a copy only?
There was hard and plain. CA number 16, 17, 18, 19, and 20. There are 5 applications. So, when
Mr. Chaudhary, where is the opposition?
this is the when we can
What is the original opposition?
There's an admission in my view.
No, original opposition has to come on record. Did you file it at any point?
Yes, I have filed
When
it.
did you file it?
So it was filed because this matter was hard.
You never filed it.
Yes, I have filed.
I have been served.
No. Official liquidator was directed to file your opposition within a week from date. You filed in the department.
No, that was not.
In view of the fact, that first affidavit was not being pressed. So
Oh,
Lordship said again file it. They have still not filed it, handing away the old opposition, which was
the
not.
old opposition admits their ownership.
No, yes, on last occasion I have stated that official may have some objection, but I find from my copy that there is no objection on the part of the official.
That's correct.
So, one of this application.
That's para 11. Therefore,
You also kindly keep my evidence of opposition on record, Manoj. I have stated last time.
So the property has to be released when they have disclaimed. That's the The affidavit- the photocopy of affidavit in opposition handed over by learned counsel for the official liquidator is taken on record and treated to be the original. Which of the affidavit in reply filed by the petitioner is also kept on record. Which of next para, upon hearing learned counsel, it transpires that there is no dispute with regard to the fact that the present petitioners are the heirs, only one applicant. You are the sole heir.
no, there are another 4 of us.
Very well. The present applicant is one of the heirs of the deceased original owner of the property in question, along with 3 others. First of next para. There is also no dispute to the fact that the company in liquidation was merely a tenant in respect of the property, and as such, the said property cannot be the subject matter of the process of
It's not the part of the.
no, you have admitted that you have admitted in opposition that yes,
Yes, para 11.
would not be a part of the liquidation estate at any point of time. Question. Accordingly, CA 16 of 2023 is allowed, thereby in terms of prayer B of the application. Question. This much will be that is sufficient.
Great one.
Who are you?
The applicant in.
110, your application is for?
My application is.
I have allowed their application.
Only this.
Yes.
109 not allowed. 106 not allowed.
It a 10. 109 allowed.
She opens the paper, may I in a nutshell indicate the facts. But the property in respect whereof my client has the registered deed of conveyance is not and was never a part or owned by the company liquidation. The property was owned by a separate owner individual who had engaged a partnership firm to develop the property. Now, this partnership firm had something to do with the company liquidation, but they were engaged only as developers on revenue sharing basis. That development agreement was cancelled by the owner.
You were the owner.
I am the flat, one of the flat owners.
The owner entered into a development agreement with the
landowner
partnership firm.
had entered a development agreement with a partnership firm.
What is the link between the partnership firm and the company?
They are saying the name is similar, Indudi, and it is the case that they are somewhere related. The firm is related with the company liquidation.
Then
This development agreement was cancelled because the developer partnership firm did not take any step. This developer partnership firm had filed a suit assailing the cancellation, which was dismissed for default. The building was constructed by engaging a third-party construction developer. Now, because one of the tenants in this flat which I have purchased happened to be a director of the company liquidation, who was not a tenant but was a trespasser, happened to be a director of the company liquidation.
one of the trespasser in what? In the newly constructed?
Is the newly constructed building. Happened to be a director of the company liquidation. The official liquidator is seeking to take possession of this.
Is there any suit pending at your
Yes.
behest against this
Yes,
person?
not my base, but
Owner.
for my vendor, the owner of the property, had filed a suit for eviction.
What is your locus standi there?
I have subsequently purchased. That suit was
What happened to
filed-
that suit? You
Yes.
did not participate there.
No, I was not there. I was not in the picture. I didn't.
No, but subsequently you see your purchase.
I to evict that trespasser, the owner had filed a suit.
What happened
for
to
the
the suit? What happened? What did it
decree of eviction executed, shown up. I purchased that property subsequently. Now the official liquidator is coming to take possession of my property in respect whereof I have a registered deed of conveyance from the owner of the property. So I have taken out this application for this. Now I will take the lordship to the there is no iota of evidence in the affidavit in opposition also. Way me and my involvement with this.
What is the stand taken by them in the office?
In the opposition, they are saying that some funds have been infused by the company liquidation into that partnership firm developer. So they have that development was cancelled. They did not pursue that. The suit was dismissed for default. Construction completed through engaging somebody else. So
But
they
suppose
did
if you're
not-
taking their best case, even if some fund was infused by them in that partnership firm,
no right in the property. And also the development agreement is only on revenue share. Apart from the fact that it was
no right in the property.
and
I
I
mean,
think-
show me that.
and cancel must before the application of winding up file. Long back.
Cancel and
Suddenly,
this.
suit dismissed.
Their
for
suit
default.
was dismissed also.
Yes. Not there. These are things.
I'm sorry.
Officially liquidated the
Partnership.
suit filed by the partnership from developer. It was dismissed for default long back.
You have annexed all those documents.
Yes.
What do you say, Mr. Chaudhary?
I think page 8
Of
of my application. I've given yes. And next,
please.
Clause 7 of the development agreement provides that both the developer had no allocation of title, but only had to write a percentage of revenue and who joined as confirming party in the sale transaction. Then it further appears due to non-compliance of the contractual obligations of the said development agreement, duly cancelled on 20th August 1993. After completion of the building work, the development agreement was cancelled. Against cancellation of such development agreement, an extraordinary suit number 7 of 1996, filed by the said Messrs. Into the Land Developing and Housing Complex before the Honorable High Court, which was subsequently dismissed for default by the Honorable High Court on 16th April 2005. No steps was taken for restoration of that suit.
Up to this, it goes against you.
Number of times he tried to hand over unfinished construction of Messrs. Priyadarshini, Messrs. Indodit Land Development and Housing Complex. The developer permitted one Torun Kumar Samanto to occupy flat number 2 by 1. Upon completion of construction, Priyadarshini directed the said Torun Kumar Samanto either to purchase the said flat from them or vacate the same. However, Torun Kumar Samanto refused to accede either to purchase of the said flat from Priyadarshini or to vacate the same, against which Priyadarshini instituted a suit, being TS number 123 of 2012, before the learned third civil judge, junior division at Sialda, Vikralaya, praying for eviction and recovery of funds.
Who was Messrs. Priyadarshini?
Priyadarshini is the owner of the property.
Well, then,
In this said suit, 10 February 2014, a judgment and decree was passed holding that Priyadarshini was entitled to a decree of eviction and recovery of possession against Torun Kumar Samanto. But Torun Kumar Samanto is one of the directors. Very cleverly, this suit was filed against Torun Kumar Samanto. Company was not made a part, and a decree was obtained. Next part. He was one of the Torun Kumar Samanto was allowed
if the
to.
company did not have a revenue share, did only have a revenue share, no right in the title in the property.
But the
What is the cleverness where even a blunt part person would not did the.
no, one of the company was not made a party.
Why should the company be made a,
At
it
that
had only
point-
revenue
no,
share?
at that point of time, the company was in liquidation and they were aware of it. But kindly,
Company did not have any claim in the title of the property at all.
no, but company is one of the.
According to your admission, it was a revenue share only, no allocation of
That
title.
was the agreement itself. That was the
Initially,
agreement.
it's not with the company, it's with the partnership first.
Now,
I'm taking their best case.
yes, only see page 19. Kindly see page 19. They were saying that they were not aware. The owner of the land was not aware that company already. No 446.
Company does not come into the picture at all, sir. Even if the developer was the company, it does not come into the picture because it has revenue share. Revenue does not include title.
No.
You admit that.
Once the title or this title suit was filed,
Eviction suit was filed.
eviction suit was filed.
Eviction suit is also labeled as a title
Yes,
suit.
not against the or not against the company.
Company does not come
Yes.
into the, why should it be?
No, because the company, one of the director was occupied one flat. One flat was occupied by him. He was allowed to be occupied as a tenant.
The company occupied, the company did not have a right itself to occupy. It put in somebody else. So vis-a-vis the owner, actual owner, who were all along the owners, he was a trespasser. He may be a director, a valued director of the company.
No,
But
the suit was filed.
But why should the company be included? The company does not come into the picture. As far as they are concerned, they not them, the owner is concerned, I am the owner. I see a company that I enter into a development agreement, the developer has a revenue agreement with, no title. Now developer puts in its director. No, then I will file a suit against the person who is sitting there. How does the company matter to me? Even if it was the company and they say it was not the company, it was a partnership firm.
But the landlord, they never pay any further contribution, revenue contribution either to the official liquidator or the company liquidator. It was 60.
That claim is against the landlord. That is not a charge on the property.
No.
That cannot be a charge that does not go with the property unless it's a charge on the transfer of property. You know that. It's a charge.
The company was the developer. The property was developed, and at the midst of the development of the property, or the development agreement was cancelled, and the suit was filed against.
But the company was not a company then. Page 55, please come to page 55 of their application. The company, if the company you say was a partnership firm, the agreement was entered into a partnership firm by the same name. So it was not even a company. The legal connotations are page 55.
Kindly see.
Second last line.
Yes, my opposition order kindly comes to page 90. My opposition. Page 90.
Page 90.
Kindly see, this is the letter. Madam, who has written this letter? What was the interest there for writing a letter? This is the Priyadarshini who was the landlord.
Priyadarshini is not even defined here. It could Might have been the Priyadarshini who imposed the emergency also.
No, kindly see my lord, the contents of the letter.
Which Priyadarshini? Who is Priyadarshini? A letterhead of Priyadarshini at Damdam Road. No description of Priyadarshini.
My lord, the Priyadarshini is the landlord. As my lord, my lord.
Yes, the partnership from Priyadarshini.
Yes, Priyadarshini. My lord, kindly see the letter, contents of the letter. We may inform you that by an order dated 11.
We are the partners of Mrs. Priyadarshini. The first sentence is.
Yes, yes.
But this is a company in liquidation. So how do you relate the two?
No. They are asking the official liquidator.
Who are asking?
Priyadarshini, the partnership firm.
The partnership firm.
Yes, they are
And
asking
you are the official
I am
liquidator in
the
charge.
official-
This is a company now.
Yes.
So firm and company are different juristic
No,
entities.
that's absolutely, but my lord, my lord, Priyadarshini, my lord, the official, they are asking the official liquidator, kindly see, my lord, we may inform you that by an order dated 11 March 2004, passed by the India above matter, the Honorable Justice was pleased to admit the above winding up petition and appointed you the official liquidator as the provisional liquidator of the above company and directed the possession of all the assets of the company. The application was made with another chance. However, we being the severally harassed by C. Pankaj Krishna Dekar, ex-chairman of the above company, by filing frivolous litigation against us. So that is the joint receivers were appointed by this only.
Therefore, Priyadarshini is saying that Indradeep, this company,
Yes. But in this connection, what page 2, paragraph, page 20, paragraph. In this connection, it may brought to your notice that in the said composition did not in the capacity of its chairman and receiver of the above finance company is still occupying a flat in flat number so and so on the ground. Complex is still carrying on unlawful activities in spite of orders passed by the civil court of law, which got it prudent to bring above back to justice.
but this doesn't create a right in your favor. And not your, I mean the company's favor.
Yes, but my lord,
They don't admit it.
but
Right?
my share was not paid. Who will pay? My lord, the development agreement was cancelled after completion of the entire.
That was in a regular suit that was upheld. That cancellation was challenged and upheld. That cancellation was challenged by the Indradeep.
My lord,
The company in liquidation itself
Yes,
challenged it
yeah,
and
that-
lost a suit, civil suit, which is
my
binding.
lord, that was for dismissed for default, and my lord, an appeal was also filed.
Oh.
So that was also my lord, dismissed.
That's
for
an additional
default.
information.
So, my lord, but I find something inside. My lord, it is a collusion, my lord, definitely, but obviously, but I do
Policy,
not
but
have.
between whom that is in
Yes, my lord, I do not have any documents even except this.
I'm sorry, public interest has to suffer again. The present application has been filed.
The company liquidation is not the developer. Your lordship will get confused by the name. Kindly sees the cost title with regard to this matter is into the General Finance and Investment Company. The developer is not into the kindly sees page 8 of their opposition. They are possibly Roman 3 of the rules of it.
Land developing.
Land developing housing complex. So they are completely, this is misconceived. A. B is that letter concerns a different flat, 3 by 1. Mine is 2 by 1. There, kindly see page 19 and 20. At page 20, it's flat number 1 by 3. Mine is 2 by 1.
The present application is one for disclaimer in respect of flat number 2 by 1 in building number 2 in one Indodeep, INDODEEP housing complex situated at 256, Damdam Road, within bracket earlier 219, Damdam Road, Kolkata 7,74,000. Push of next para. When counsel for the petitioner contends that the said property has wrongfully been sought to be acquired by the official liquidator, who is in charge of the company in liquidation. Full stop. It is submitted that the original owner of the property, one Messrs. Priyadarshini, a partnership firm, had entered into a development agreement with one Indodeep land developing and housing complex. Full stop. Next para. Subsequently, in view of the developer having not performed its part of the contract, comma, the development agreement was cancelled. Such cancellation was challenged by the said Messrs. Indodeep Land Developing and Housing Complex in a civil suit. The said suit was dismissed for default. Subsequently, comma, the construction on the plot was completed by a third-party developer at the behest of the owner, Mrs. Priyadarshini, and the flat in question was sold to the present applicant. In the meantime, comma, the said previous developer, Messrs. Indodeep Land Developing and Housing Complex, had apparently introduced one of its directors as a trespasser in the flat. A regular eviction suit was filed and a decree obtained therein, and such trespasser was ousted from the property in due process of law. Next para. It is argued that the company in liquidation seeks to extend its tentacles to the said property merely on the strength of some alleged dues from the developer to the company. Next para. However, comma, it is pointed out that the company in liquidation is one Indodeep General Finance and Investment Company Limited, comma, which is distinct and different from the partnership firm Messrs. Indodeep Land Developing and Housing Complex, comma, which was the initial developer in respect of the property. As such, comma, there cannot be any claim at all insofar as the flat is concerned. Next parallel, counsel for the official liquidator submits that cleverly, comma, the company in liquidation was not included in the eviction suit, and an expert and a decree of eviction was obtained. Next para, it is submitted that the suit, civil suit, challenging the cancellation of the development agreement was dismissed not on merits but for default. Although, comma, in his usual fairness, comma, learned counsel for the official liquidator points out that an appeal preferred against the same was subsequently dismissed as well. Next para. A perusal of the development agreement annexed to the application shows that in the first place, comma, the developer was a completely different entity, comma, being a partnership firm having the name of Messrs. Indodeep Land Developing and Housing Complex, comma, as distinct and different from the company and in liquidation, which is a company incorporated under the Companies Act 1956 by the name of Indodeep General Finance and Investment Company Limited. Thus, comma, in any event, comma, there is no nexus whatsoever between the property and the company in liquidation. Next para. Even if the best case of the official liquidator was to be taken and it was to be construed that the company in liquidation was the first developer, comma, the said development agreement was cancelled and the cancellation affirmed by a competent civil court by virtue of dismissal of the suit challenging such cancellation for default. Such decree was also affirmed up to the appellate court. Next para. Even thereafter, comma, an eviction suit was duly filed against a trespasser in his independent capacity, and such eviction decree ultimately culminated in the said trespasser being ousted. Irrespective of the fact, comma, even if true, comma, that such ousted trespasser might have been a director of the company in liquidation, comma, the same does not have any bearing whatsoever with the claims of the company in liquidation as insofar as the flat is concerned. Next para. In any event, comma, the company in liquidation had no nexus with the flat, and even if there was a claim with regard to the company, comma, the same did not carry a charge on the property, which is the subject matter of the present application. Full stop. Next para. Despite the valiant efforts of the official liquidator, comma, this court fails to convince itself that there is any nexus whatsoever between the company in liquidation and the subject flat of the present application. So, accordingly, CA 17 of 2023 is allowed, comma, thereby directing the official liquidator to disclaim the flat bearing flat number 2 by 1 in building number 2 in Indodeep housing complex situated at 256 Damdam Road within bracket earlier to 19 Damdam Road bracket closed Kolkata 7,74,000 with immediate comma as described in paragraph number 3 of the application bearing CA 17 of 2023 with immediate effect. Within
In 5 minutes, you got shit, heard us and encompassed.
I earned my bread by doing that. So I'll not be paid.
We have been going through the matter for so many days.
No.
But only one thing that I should point out here.
Yes.
In one place, you should have mentioned that the developer had impacted one of its directors.
Yes.
So the developer had the initial step, not even if taken to. So
Yes, a developer should be the
and
company.
No, the developer is a partnership. Impacted somebody who happens to be a director of the company. That one person.
Developer had inducted the property. Developer,
One of its directors is
developer had inducted one of its directors. I'll correct. I'll correct it.
so the developer is a partnership. So it's not a
With immediate effect, as said.
possession is with us.
With immediate effect.
Possession is
Uh-huh.
it's a law.
Oh, what's happening? Okay, seriously. Thank you. No, you have not paid even for possession being handed over.
The
Possession has to be with them, otherwise the ends do not meet. Because the eviction should culminate it and they were given possession and all this, then every entire thing will go.
yes.
Who is he?
Mr. Shashwat Naik was appointed, but position was not taken. They had filed a report indicating
He has been discharged.
and possibly for a task organization. Yes,
Discharged.
Yes. Because there are several disclaimer applications.
Otherwise, he will be affected by this disclaimer.
No. There are several disclaimer applications in respect to this company.
Because Lahir is waiting with one. Yes. Allah
State Bank of India, being a
Okay.
secured creditor
Yes.
for disbursement of a portion of the admitted claim.
Why a portion?
Not the entire, there's a huge amount of claim which has been admitted. Not there are two properties involved.
Yes.
Two properties of Faridabad, one plot number 99 and one plot number 107.
Yes.
With respect to plot number 107 and 6 thereof, there is a dispute. Today, my prayer will be for disbursement of that portion because in the light of reports, one filed by the official.
Your share out of that sale proceeds. That will be the entire.
That's the entire amount of it because that was remortgaged with the state bank. Now, with respect to the plot number 99 of it, there's a pending investigation. Why? Because that plot was
So you want to reserve your rights regarding that?
99, but for the disbursement, the official liquidators report also lodged.
Yes.
We will file in compliance of order dated.
Report the Shall report The report is not here. What is the report?
Underline.
The underlined is, but you are sure you have filed.
Yes, fine.
When was it filed?
January 24th.
What you can number put it?
Also directed from the CBI. Yes.
16 January order. The difficulty is, I mean, now I have ensured that all the orders are there. All the orders are not there, in particularly in the original side. I mean, the files don't contain all the orders. That's a very difficult aspect of the matter. I mean, I don't know, because I cannot blame them. They were not there at that point of time. I don't know.
I had this was the
Can I keep that on record? Yes.
There was a direction upon the CPI to file a report. But, I think the CPI file a report or not, I do not know, but I have got in a possession.
has handed over copies to.
Nothing is there. Acha, what is your stand on this? Their papers?
Report needs to be.
No, I'll direct an inquiry where the papers are. But regarding their the state bank,
Yes, we went along with the CPI's report, my lord.
CBI's
Because there is it's an ongoing investigation.
have you got a copy of the CBI report? No. What is your stand on that? I mean, even if there's a regarding 109, this
Investigation is going on.
that is regarding 109. They say.
That's from the CPI, my lord.
It
The
is-
official
No,
cannot.
no. 109, the investigation is not restricted to 1099, not restricted to that.
Because if you
Also 107.
why not can you have a look at the request of the paragraph 8?
No, I'll refer the originals. I mean, it cannot
Paragraph
be.
8, my
What
lord.
is the report?
May I take- Direction for filing a status report and a direction upon the CBI.
Your
to file
stand
a
is that if the CBI investigation is going on that covers 99 as well as 107, then it cannot be disbursed at this point.
As per the report of the CBI, because since there is an ongoing investigation, we cannot, I think so, that may I not be wise enough to, because we are ready to pay the interim.
I understand.
Amount.
What do you say regarding the CBI?
By one paragraph 6 of the report by the CBI, which says that this
Well, please give me a copy of the CBI. Whatever.
paragraph 6. The dispute is with respect to plot number 99, whether the said plot was also mortgaged with the Haryana State Industrial and Infrastructural Development Corporation. Lordship will take up paragraph 6, states it is further alleged that they had unauthorized mortgage the same property, plot number 99, sector 20.
They means the company in liquidation.
The company. At Faridabad, the factory and land building of HSIIDC without the knowledge and consent of the consortium banks on the basis of forged documents purportedly issued by Faridabad main branch of State Bank of Patiala, the then State Bank of Patiala. What they had done was that forged the NOC issued by State Bank of Patiala with respect to only plot number 99.
Yes.
So with respect to Lordship, this complaint is also at the behest of State Bank of India. The investigation, Lordship will take up that the complaint at paragraph 1, the case has been registered on this date on the basis of complaint that is dated 21 of Sri Shashinath Mishra, Regional Manager, SBI RBU 1. There is no dispute. Even the liquidator's report, Lordship, it clarifies that the dispute is only with respect to plot number 99. 107, Lordship, the liquidator's report is okay.
So I don't have a copy of that.
Last paragraph. We are not standing in the way making the interim payment. We are ready to make that amount. But because of the CBI's report, my lord, the paragraph 8, if your lordship so pleases, we can make that
Paragraph 8 of the liquidator's report, Lordship. That is of your report. At paragraph 8, a meeting was held with the secured creditors to discuss and decide the issues related to charge assets in details of 6,000 November 2019, when SBI submitted the exclusive charge over plot number 107, HSIIDC submitted documents with copy of F8 and a copy of memorandum of deposit of title in the letter of the letterhead of State Bank of Patiala, showing no objection given by SBI in favor of HSIIDC to create pari passu charge with SBI. SBI further denied the charge of HSIIDC in regard to plot number 99. The above dispute, next paragraph, 99, and also denied the documents submitted by HSIIDC and stated to be false. Above dispute between secured creditors, SBI and HSIIDC in regard to charge of property at plot number 99 till submit, it appears from minutes dated 6 November 2019 that SBI has exclusive charge on the property at plot number 107. And in the concluding part of the report, they also say that there is no difficulty. This was the
When this report was filed by the official liquidator, the CBI's report wasn't there.
No, not
So,
there,
but
and you
the
don't.
losses
You
of
take
the
a you take a neutral stand. You take a neutral stand, but
Yes,
your
yes.
impediment is the CBI.
We are ready to make that payment.
Acha,
And one
can you please ensure that photocopies of these two reports are filed in court, because these are your copies? Can you file photocopies of the CBI report as well as your report? I'll pass my orders on the premise of this. So please ensure that those copies are filed in the course of the day. If I can retain these copies, I can retain, or
my lord.
then I'll retain your copy. Thank you. Then I will report the details that I received. The present application has been filed by the State Bank of India for release of the dues of the State Bank of India from the funds of the company in liquidation, insofar as it pertains to
there was with respect to the entire sale proceed. Now only a
Portion of it will be released, my lord. That is only
insofar
one.
as
That
the state of first of the insofar as at the time of arguments, and counsel for the State Bank restricts the prayer of the State Bank for the time being to the sale proceeds in respect of plot number 107 in sector 24, Faridabad, Haryana. Full stop, next para. It is contended that although there is an ongoing investigation by the Central Bureau of Investigation, there is no mention in the report of the CBI filed before this court with regard to plot number 107, although there are certain allegations which are pending investigation by the CBI, insofar as plot number 99 in sector 24, Faridabad is concerned. Push up next para. Learned counsel for the official liquidator submits that the official liquidator is taking a neutral stand, inasmuch as in principle there is no impediment in releasing the dues of the State Bank of India stroke secured creditor. So, however, it is pointed out that in view of the ongoing CBI investigation in respect of the company in liquidation, the official liquidator was hesitant in releasing such funds. Next para. At this, learned counsel for the petitioner bank also places reliance on paragraph number 8 of the report filed by the official liquidator, which indicates that the dispute is restricted to plot number 99. Next para. However, learned counsel for the official liquidator submits that the said meeting referred to in paragraph 8 of the report was held prior to the CBI report coming to the knowledge of the official liquidator. The copies of the reports filed by the CBI and the official liquidator are treated to be the originals, since the originals are not detected in the court records. Coming to that later, it transpires from the report of the CBI that the CBI investigation, as of date, does not involve plot number 107 at all. Next para. Since the bank restricts its prayers to the sale proceeds from plot number 107 and not plot number 99, comma, the latter being under the scanner by the CBI, comma, there cannot be any impediment in the funds in the dues of the applicant being disbursed from the sale proceeds only with regard to plot number 107, comma, sector 24, comma, Faridabad, comma, Haryana. So, next para. Accordingly, the official liquidator is directed to disburse the dues of the
That is
entire
the-
intercept.
No, not the adjustment. It is only a portion of it. My your lordship, paragraph, sorry, page 6, 5 and 6. Last. Na, India ka portion.
1090 that or
Measure my lord. An increment payment may be made.
what is
within
that? What
1
is that now?
Page 6,
Page 6, 1090,
yes, my lord. That is the amount can be released at right.
an amount of
And the balance amount to be disbursed.
I'll keep the application paid.
Yes, it will abide by the result of that report.
Yes.
According to the official figure is disbursed the
Disburse an amount of rupees 10, 90, 00, 000, as an ad hoc disbursal in respect of the dues of the applicant bank, from the sale proceeds of plot number 107 at sector 24, Faridabad, Haryana. So, next para, the rest, the disbursal of the rest of the dues of the applicant shall abide by the outcome of the application. Next para, the application shall next be listed in the monthly list of August 2024. The CBI shall file a further status report shall file a further report updating the present status of the investigation with regard to the company in liquidation on the said returnable date upon circulation of advance copies to the learned advocates for the petitioner and the official liquidator. The
it's required to make the payment
Okay.
because it's all kept in fixed deposit.
আচ্ছা তাহলে যেটা বললাম যে রিটার্নেবল যেটা বললাম in the monthly list of August না করে shall next be listed on August 22, 2024.
Fixed deposits may be permitted to be disbursed the entire amount with interest, 10 lakh 10
Interest
Not
rate
right now,
is
this is
just
an ad hoc
let them be
payment
happy
for the
with this amount.
So,
Interest
next
will
para.
be taken.
A server copy of this order shall be communicated to the CBI by the learned advocate and record for the petitioner in the meantime. তারপরে একটা paragraph. It is alarming that papers are missing from the present records. More importantly, neither the report filed by the CBI nor that filed by the official liquidator can be traced out when the matter is taken up by this court. Next para. The registrar original site is directed to immediately conduct an inquiry and to ascertain the whereabouts of the balance papers of the present file. Such report shall be filed before this court by the end of August 2024. It is expected that the registrar original site shall also indicate the involvement of the persons who are responsible for the misplacement of the said records and also indicate the penal measures which ought to be taken against them in such report. Such reports shall be filed before this court before and by the end of August 2024, irrespective of whether the present matter is listed or not. A copy of this order the present file shall immediately be forwarded to the registrar original site for taking appropriate action on the basis of the above order. Next one. Yes.
directed sort of a report from the register, that there, my application was a refunding of the earnest money.
Yes.
Line original side to earnest money. One sum of 4 lakhs. One sum of another direction sort of a report.
This was only to ascertain whether those sums were
Yes, sir.
deposited.
So my application was seeking based on 85 of the demand of the line.
Just give me the background once.
There was a sale offer was known.
Oh, you were an unsuccessful bidder.
Yes. Sale has not been complied with. They have participated with, see, as the state is not contacted.
So there is no counterclaim against your this. The official liquidity, yes, but is okay. The demand drafts are here. So should I direct that those to be handed over through the register or here and now? I think it will be better through the register. Then I'll send the file to the register, you take from the register and just give the account. The reports filed by the register original side indicate that the amounts as averred by the petitioner were actually paid by the VDE two demand drafts, comma, respectively being demand draft number 272309 dated March 22, 2019 for an amount of rupees 4 lakh and demand draft number 272315 dated March 26, 2019 for an amount of rupees 1, 40, 000, respectively on March 25, 2019 in respect of lot number 1 and on March 27, 2019 in respect of lot number 2. Full stop. Next para. Since there cannot be any further impediment in returning the said earnest money deposit of the applicant to the applicant, comma, who was an unsuccessful bidder, comma, the application number is CA26, comma, CA26 of 2024 is disposed of by directing the register original side to return the concerned demand drafts to the petitioner at the earliest. Full stop. The filing along with this order be communicated to the register original side immediately in order to ensure due compliance of the same. Got it. 27 is also yours. Got it. Thirdly, none appears for the parties. Oh, I see. Well, I'm just making not today. Not today. It's got it.
Listeners, for the official except 5 applications.
Is it a combined issue?
There are 5 applications, one by one, all are the same company.
Similar applications.
Connecting application with the company.
Let me take up one by one.
Can we first connected 114 and 116 altogether? Till better. 114 CA number 5 of 16 filed by us, official liquidator manner, or non-filing the statement of affairs by the ex-director of the company. Subsequently, they filed the statement of affairs in the manner of officer, official liquidator, we are process becoming practice. So,
They have filed this statement of affairs thereafter, but not approved by the court. So they filed an further application that.
For that approval.
Yes, that is 116 CA number 20 of
The
20.
intricate questions of law and input.
Then-
So I have to dispose of both them
Yes.
together.
Yes.
I'll give that approval, and
Yes, 114 and 116.
is there any particular format, or just I just dispose of the application and grant the approval?
They are filed.
Yes.
They did not file the warrant of arrest for issues. They came before the court. Undertake to assess the purpose to the official level. Sufficient time was extended to file the statement of affairs and issued to court. They cooperate. Some of the documents information has been given, but main thing has not been given.
What?
In the statement of affairs, they specifically mention cash in hand.
Right.
By them. On their side.
Where do I find that? Which page? Cash in hand?
First, second page. First, second.
Cash in hand, yes.
Yes, for 48 lakhs 91,000.
Right. 704.
And expect them, because the letter was issued, they did not.
They did not do what?
They did not hand over the
Cash.
cash, not official decree. In section 468 specifically mentioned, after the decree, all property money has to be handled. May I enter the money?
Yes.
Yes.
So you are not appearing for the application?
I am not very strict. I would be involved in getting all the money which my direct friends.
So you are-
I am assisting. my
You are rather
direct
assisting him, yes. But who is appearing for them? Should I give them a notice, another notice?
Chakraborty admitted to say appearing court number.
She is regular.
She is regular.
So I'll request you to,
Maharashtra is same. Regular.
give a notice to her, and I'll dispose of it. Otherwise, we use this. They'll come up with a recalling application. So I'll take up all the matters together. Next, not
No matter one.
I can dispose of.
No. Notice for 114 and 116. Serial number 11.
All the applications are fixed together on the next week. If they're connected,
All are connected.
Oh, my lord.
Please come. 115 serial number 9 of 2017. For the petition tender, file an application that is upon the official level of my lord to take the position of the property. That has been completed.
sale has been completed.
Position has been handed over.
Should I ask for a report in that regard from you?
Yes, they did file.
So file that report with a copy to them.
And my lord,
This is 117.
this is not, that is CA number 115. Serial number 115, my lord, is CA number 9 of 70. A separate application, 114 and 116 are connected, and 117 and 118 another.
CA 9 of 2017, that sale has been concluded.
So there are directions upon us.
You have concluded that sale.
That is done, they will file the report. They will
Right.
file the report. And 114 and 116 are same. They are not yet handed over the money to us.
Will not take up right now. Then what is?
Then 117 and 118, CA 26 and 27.
My
This is yours.
application is for dispersal of money which my management collected.
26 is for that.
That
Possible right now because we have collected all the money, including the money mother kept in the hand of the ex-director of the liquidator. After collecting all the money, we prepared a letter for directions and filing to your lordship for disbursement of money. After verified and scrutinized by the documents placed by the
Does that depend on also on the handing over of that cash in hand? Does it hand? If that is not given, then can't you complain?
If that will come to our hand, then our beneficiary of the case just
Then it will be more. The amount.
workers and other things get more money. There is a process to file before your lawsuit letter for directions. After compliance, they are claimed with proper documents. Some we have admitted, some we have received. Then come before your lawsuit letter for direction, and upon that we disburse the money in the account before that.
Yes, what you say?
my lord,
my learned friend has given the entire
Picture, yes.
picture of how this application is pending since 20. I am the 2013 is the CA which was, and 2014 the company basically. I've been pursuing this money. I had advanced $770,000 US to for purchase of some products that the supply was never made. The former directors, they siphoned over the money. There are a lot of other issues involved. Corporation Bank money was given to Corporation Bank, which my learned friend has taken steps, but the Corporation Bank has said that they have forfeited the money of a company in liquidation without the leave of the court. It's a fairly substantial amount it's been.
That has to be, they have to take steps on that.
So my learned friend has to take steps. My lord, I'm trying to, I will assist my learned friend. And I am
Then
only,
should I ask for a composite status report, including
my
everything,
lord,
whatever regarding the funds in hand now?
I say, one report has been filed.
No, up to date report. Up to date.
Then
Number 118.
You have a similar claim as your friend?
I am the only creditor as far as the company in liquidation.
What do you? I mean, vis-a-vis the company.
I'm not. I'm not a purchase of the flat. I purchased the flat in the year 2021. After that,
What is this application? Disclaimer sort of thing.
and I was out from the flat. Without my knowledge. I bought the flat.
But for that, the
One crore with
the director of the company in liquidation fund is this statement. They have to be present.
Yes.
For your application, they have to be present.
Why not? They can serve a copy of petition so that
Yes.
I would be able to assist my lord.
I'll put in.
There are a few issues which I would like to highlight.
Definitely, it has to be taken compositely. Otherwise, piecemeal we cannot. All the applications, a total charge. One token take one on each. All the applications are taken up together for hearing, since those arise from the liquidation of the self-same company within bracket in liquidation. Bracket close, full stop, next para. It transpires that insofar as the prayer in CA 9 of 2017 is concerned, the same has already been complied with in the sense that the official liquidator has already sold the said asset. Full stop, next para. However, since the erstwhile directors of the company in liquidation are not represented today to counsel, in order to effectively adjudicate the matters, the official liquidator is directed to file a composite status report disclosing the up-to-date status of the funds of the company and its assets. Full stop. Next para, such report shall be filed by the official liquidator on the next returnable date upon circulation of advance copies of the same among the learned advocates for the
For my lord.
without circulation.
For the court. My lord.
No, they may have something as well. For the timing, yes. Upon prior circulation, take it. Next para. The learned advocates on record for the applicants in all the matters are requested to circulate copies of all the applications between themselves in all the matters in order for the court to effectively adjudicate the matter on the next returnable date. The matter shall next be listed on. How soon can you do that? Your report shall next be listed on August 8, 2024. Please keep this copy with you. You can annex this to the, because I'm not referred to it because they are not there. You can either annex it to your report also, or you can hand over and react it. I have to just add to it. The learned advocate appearing for the applicant, I'll put this on the creditor. For the applicant in CA 9 of 2017 shall give a notice to the director of the company in liquidation indicating the next returnable date to ensure presence of all parties at the next hearing. In the meantime. Yes. Next.
119. 120.
Not today. Make it not today. Not today. They're not. Your application. Oh, what is the application?
Status report which has been
Okay.
the respective applications appearing before your house.
All right.
July 2023. 14th of July 2023. Status report filed.
Justice Bhattacharya was there then.
No, my lord.
Justice Kapoor was there. Justice Kapoor, officer. Winning. I mean, so many other irregularities. I cannot finish them. Don't want to discuss some of them.
One was filed in the month of June.
Not only the status reports, the entire file is
Filed
covered.
Because there were also directions for transferring the files to the NCLT. Maybe some of the files may be gone along.
Maybe there is no proper recording. Only proper recording has to be there by the court officers.
The records is
Only
very
that will suffice. If there is a recording, we know we can trace out the files. That is not. I mean, yes, but Judge had to- Status reports have got two status reports.
Yes,
Yes.
the last one is of July 2023.
Yes, got it.
Page 4, paragraph 9 onwards, we have indicated
Yes.
that CA 190 is an application taken up by the contributor, one of the contributors, my lord, for recalling the finding of order, which is still pending. And the second one, that is 120, is of, it's also recalling the order. It's with regard to your complaint matter. So complaint matter was filed by the official liquidator, and maybe some adverse order has been passed, so they want the recalling of that. One of the experts have filed this application for recalling of the order.
What is the status of those? Those are still pending.
It's still pending, my lord. All pending. And 11 and 12. 12, I will not be able to assist your process, but 121 is taken up by the petitioning creditor. Two applications they have filed. One, that is an application for seeking under section 446.
In your applications, what do you see?
Mine's only the complaint one. That is 120 complaint matter.
So what is your prayer in that?
Complaint matter is for non-filing of the statement of affairs. Now, the ex-directors, as per 554, your lordships, it's incumbent for them within 21 days of the date of the winding up, they are supposed to file their statement.
So what is the sanction if you can't? If they don't?
554, 58, for issuance of warrant. But maybe I do not know what is there in the.
Miss Razde, please give a notice, another notice and come back.
Yes, my lord.
I think
What-
one notice at least they are intended to give.
Yes,
One
yes.
notice, if they
Yes,
don't come,
my
then I'll issue warrant. What can
This
be
is
done?
with regard to
120. And the others are also not appearing.
And 1 minute, these are all the applications by the ex-directors and the petitioning creditor, my lord. So we are opposing. So
When the matters are called on for hearing, comma, being connected, comma, arising out of the same company in liquidation, comma, only the official liquidator is represented by counsel. Mr. Learned counsel for the official liquidator, comma, in support of this is CA 421,
yes.
saved by a whisker, 421. CA 421 of 2017 submits that the ex-directors of the company what have they not filed?
Statement of case.
Have not filed the statement of affairs, and as such, warrant of arrest ought to be issued against them. Question next para, in order to give a last opportunity to the ex-directors of the company in liquidation, comma, the learned advocate for the official liquidator is requested to serve a notice on them indicating that the matter shall next be listed on August 8, 2024, when appropriate orders shall be passed. Pushpa, insofar as the other applications are concerned, comma, since none appears to move them, comma, those may also be listed along with
I think
CA 41 of 2017 on August
I
8.
know. May I also this last order passed in 19th of July 2020, there was a direction to serve the petitioning creditor and the secured creditor, and that we have done on 24th of July 2022. May I please letter on record, my lord, that but they have not done that. In spite of the letter.
No,
The
Ms.
secured
Razak,
creditor and
can you please use an affidavit of service for this? Just put it on an affidavit of service, put it on oath, I'll keep it on record on the next. Yes. We can annex this also in the affidavit of
Yes,
service so that it's comprehensive.
yes.
8th has to show. How it is. All the
8th of
applications,
August.
8th of August, yes. Sorry. Yes. Great. See. Great. So, Mr. Das, I'll give them the thing.
The official liquidator states in its affidavit in opposition that the property belongs to the company in liquidation, but was a lease hold property that is expired before the company in liquidation. So official
So
liquidator.
this is a disclaimer. You have a
Disclaimer application. So official liquidator has nothing to do.
And what is yours? So what is the use of reply? You dispute this stand?
Might not be no.
That on the
ground of director at the time they get the guarantee mortgage, but they were no longer directors after. What is the problem?
maybe there. Anyway, there is on the prayer of the petitioner, comma, the time for filing affidavit in reply to the affidavit in opposition filed by the respondent is extended for a fortnight from date. The matter shall next be listed on August 8, 2024. Fortnight is sufficient.
On the list for phone company privatization.
Should
Why we have the binding up.
Either way, none appears for the applicant, let the matter stand adjourned for the day. Please come back on the next. For the number of people. बोलो. Yes, sir.
I agree with the on behalf of the applicant company. Made area logic. And finding up the issue for file against me. I company model pathway.
The official liquidator should be present. No? Not that they, that's
No,
it.
no, not that.
That's yes.
Someone from the order admitting to finding up the.
Yes.
We wait up to the.
Right.
If every subject to pick up some of the order admitting finding up. Any access on it.
Right.
Will find kindly come to the journey of it.
Yes.
Well, kindly take these cookies on. Last paragraph. Last people, we have been successfully part they have been allowed. The order dated March 22, 23. Matter is remanded back to the London judge to be hard appeal. However, to take the bona fide of an appellant, we ask the appellant to and that should be taken. By the same kindly comes.
You were the appellant.
I will be appellant and be covered. Our page 16 is the document and kindly come to page 16. The right.
Yes.
On 2nd June 2015, that is time there. Well, what happened here? The matter was transferred to the Honorable National Company Doctor. And when the National Company Doctor was the matter, the winding up edition on 26 February 2022 at 8:09.
This is for divorce, not for.
Then, my lord, on 21st March, as we went, I requested the register to visit the fund. This is the money, so deposited. And my lord, the register like to state that in terms of the supply of the register is that paid by lord. That paid by lord. 28.
Right.
And order.
So you want this is only for leave to take back because it is now it has gone to the NCLT.
NCLT matter is
So the amount is lying where? Here.
in the register of your
Where? No, one submission. Yes. Of Roosevelt, yeah. So you're under investigation.
The company is under. I'm not. An order was passed by the form on asset disposal. Fund the investor. Committee function. So when my humble submission, let the money be transferred in the name of Chairman Asset Disposal Committee. So that the money is paid.
Do you have any papers to show exact the name, something to show so that I keep it on record and pass orders? Yes. Thank you.
Page 4 of the committee. Now, the committee has been reconstituted subsequent. But the chairman is different. Now, one member from India and one member from economic office.
Fair. You were a group company of Roosevelt. Fair. Thank you. The present application has been made with the innocuous prayer of release of an amount of rupees 12 lakh, which was deposited with the register original site by the petitioner company in terms of an order dated May 8, 2015. Mr. The short backdrop of the case is that a winding up petition was filed by one
Elite furniture. Elite furniture.
yes by one Elite Furniture Private Limited. Mr. From the order passed therein, an appeal was preferred by the present petitioner, which was allowed in part, remanding the matter back to the first court to be heard afresh. To test the bona fides of the appellant stroke present petitioner, however, the appellant was directed to deposit a sum of rupees 12 lakh with the registrar, original side, which was duly deposited, as substantiated by the annexures to the present application. Subsequently, by an order of a coordinate bench, the winding up petition stood transferred to the National Company Law Tribunal, where it was subsequently dismissed for non-prosecution. Next para. However, the amount deposited by the present petitioner is still lying with the registrar original side, although there is no LIS pending in that regard. Next para. Learned counsel for the petitioner, in his usual fairness, hands over a copy of an order dated May 11, 2015, from which it transpires that in the meantime, an investigation has been initiated and is ongoing in respect of Rose Valley Real Estates and Constructions Limited company, of which the petitioner is a group company. It is submitted that the amount to be so refunded be deposited with the Assets Disposal Committee, which has been formed pursuant to the order dated May 11, 2015, with regard to the said company in WP 275 of 2015. Next para. Upon hearing learned counsel for the petitioner, the court finds that there is substance in such submissions. Accordingly, CA 1 of 2024 is allowed, thereby directing should I direct the registrar original side directly to deposit to that?
Usual given the bankruptcy or the check of
Very well. Accordingly, deduct what? Poundage. No, the interest is kept in an interest bearing. Yes. Accordingly, the registrar thereby directing the registrar original side to release the amount of rupees 12 lakh along with interest accrued thereon to the Assets Disposal Committee formed by virtue of the order dated May 11, 2015, passed in WP number 275 of 2015, after deduction of due poundage. Such payment shall be made by a demand draft within 4 weeks from the communication of this order to the registrar original side. The order be immediately communicated to the registrar original side.
Maybe by your check obligation, unnecessarily, even the charges will be
by way of a demand draft or mode specific order by a suitable mode. By demand draft by a suitable mode.
Asset disposal two accounts, one the administrative account, other the investor. It should go in the investors. And
What you say that?
Asset disposal committee investors account. PNB two accounts are being invested. One is administrative account.
Then we have to give the number of that account.
And just mention the investors account. That is the point where
the assets
allowed the amount of that is to the assets
to the investors account maintained by the assess committee with the Punjab National Bank. With the Punjab National System, last chapter building, the petitioner shall furnish the number of the said account where the money is to be deposited to the registered original site within a week from it.
My lord, may I be permitted to explain? My lord, the parties have settled the matter, my lord.
80.
80. Today is this, my lord.
Yes.
We just want to file a control certificate and get tomorrow.
Tomorrow is to be mentioned. It is the 20th.
My lord, I requested that you, ma'am. Mr. Aditya Kapil will be straight.
Calcutta PM. Item 80.
80 equal.
We item. Yes.
My last request. My lord, the next matter, I will not want to this regard to the Avani projects matter, my lord. Where I have also filed an application is not appearing. I may give the
Give the slip. Give the slip.
It will appear on the next week.
What was wrong with it? Yes.
Getting 6 hours that application in. Next week, I have got a matter.
Next 2 weeks I will not be there. So unless it's mentioned as urgent, then it won't be there.
It is urgent. It is running.
So if it's mentioned as urgent before the court taking up urgent matters, then look out for that.